top of the hour, or so according to whatever clock we're using. I call to order this meeting of the Zoning Board of Appeals for April 6th. We'll begin with administrative items. We've got two sets of minutes, March the 2nd and March 30th. You have in front of you, and which was distributed also about an hour or two ago via email. It's a red line version of the March 2nd minutes. These contain red lines of, I guess, Andy DeMoore.
Yes.
And myself.
And Ernie.
Oh, and Ernie. Okay, great. So why don't we just go through those? I don't know if anyone's got comments on pages 1 and 2. Oh, actually, before we get going, I just want to double check. Lenny, I see your face. Just want to make sure you can hear us, correct? Yes, okay. All right, and Maria, can you just confirm you can hear us as well?
Yes, I can hear you.
Okay, great. Sorry, just wanted to make sure that it wasn't just video and not audio.
It doesn't.
So Lenny, you're on mute.
Oh yeah. Hey Lenny, can you turn yourself off mute? Yeah, you're on mute.
We don't hear you.
We can see your lips. But we can't hear you.
Am I off mute?
There you go. That's perfect. Excellent.
Oh,
Thank you,
good.
Lenny.
Very good.
Okay, just want to make sure. Okay.
Good.
All right. Anyways, back to the minutes of March 2nd. Any comments, edits, concerns on pages 1 and 2? Anything on page 3? Page 4. Page 5. Six. Page 7. Page 8. And anything on pages 9 or 10?
I move we approve the red line minutes of March the 2nd.
Second.
Tiger still on? Sorry. We have a motion, we have a second. Any discussion? Hearing none. All in favor of accepting the red line minutes of March the 2nd? Aye.
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 Motion passes. The minutes are
Aye.
adopted.
We were just saying, because some members are in Zoom, it might need to be a roll call vote.
Okay, I can't just simply acknowledge what's happened on the video.
No, anytime you have a remote voters, it's supposed to be a roll call vote.
Oh, okay, all right. In that case, we'll take a roll call vote on the minutes. Andy Crosby?
Yeah.
Andy Moore?
Aye. Aye.
Maria?
Aye.
All right, and chair votes aye.
Lenny. Oh, that's
Wait,
right.
the associate member, so.
That's right.
Do I vote on the minutes or not?
No, it's only the voting members on the
Okay.
minutes.
Oh,
So,
okay.
but I will acknowledge that but
Yeah.
okay.
Aye.
All right, let's move on to the minutes of March 30. These, we've redlined minutes that were put in front of you and were distributed earlier. Those are the edits of Andy Demore and Ernie too, or not, just Andy?
Ernie had one comment.
On these as well? Ernie? Yeah, oh, you, okay. Only because I wasn't able to put red lines in for this yet. Okay. All right, so let's take a look at page 1. The paragraph on the page, Ernest expressed concern regarding the lack of information from the property owner, should be from. Page 2. The only thing I might suggest is under the general section, paragraph 2. First of all, Lenny's last name's misspelled. And the second sentence where it says the board reminded him, I think, can we just change it to say the board noted? Okay, thank you. Page 3.
On findings 10 to 11, the section says 9 to 11.
That's a good point. Sorry, what? Where was that?
The findings 10 to 11 says 9 to 11.
Also, should the title be findings 10 to 11? page 4. Page 5. This is a picky thing, but there's a few places where the word finding is capitalized versus not. So like finding 23, the board asks for the finding, it's lowercase, but then number 24 it's capitalized, so just double check for consistency. Finally, pages 6 and 7.
I move we approve the red line and edited minutes of March 30th. Second.
We have a motion, we have a second. Any discussion? All right, hearing none, take a roll call vote. Andy Crosby?
I abstained, I wasn't at the meeting, so.
That's fine. Any more?
Approved.
Ernie Dodd?
Aye.
Maria McFarland?
Aye.
And David Hartnagel, aye. The minutes as redlined are adopted 4-0 with 1 abstention. All right, moving on to our next matter, which is the continuing deliberation, 41 Birch Hill Road, the appeal of the decision of the building commissioner. At the after the conclusion of our last meeting last Monday, Michael took the draft decision and made further edits based on our deliberations. That version was circulated amongst the members of the board. Members were encouraged to provide direct comments, proposed edits, etc., to Michael, which have now been consolidated and are in the new draft decision that is put before you and was circulated by email earlier this evening prior to the meeting. There are also included are non-specified comments for discussion, which I believe these are yours, that are from Ernie as well. And just to be clear, the edits that were incorporated into the draft decision are from myself, and well, I'll ask you, which edits were incorporated into the draft that we have right now before us?
Andy and you have done inline edits. Lenny, Ernie have provided just comments on ones without a specific word choice.
And you had something to do, right?
And then I added in a few based on.
My edits weren't in the new separate document.
Some of them were changing the word. They were a separate document,
Okay, got it.
but they were changing the findings themselves,
Okay.
so I just incorporated it.
Okay. Thank you. Okay.
And if there was a dispute between the two members, I noted it in the margin.
Yeah, see that.
Which one to go forward with.
Gotcha, okay, so the edits in here, so ED's Ernest Dodd, MS obviously you,
Yes.
DH I guess is me, and then, I think there's going to be, that I see. Oh, LG would be for Lenny. Okay. Excellent, okay. We also, at the request of some of the members, we also have town council here tonight, so thank you for attending, in person. So I think the easiest way to start, I'll open it up for the board. So we've got to go through the decision. We also have town council here who was brought in particular to answer some, I would describe as more general conceptual questions that I think will influence the decision. So I'm personally inclined to start there rather than going through the decision itself, because I think that's putting the cart before the horse. Unless anyone has disagreement with that, I think that's how we'll kick things off. So I'm just going to open it up to the board to the extent that they want to start by asking council questions. That would be great. I'll actually just ask one clarified question. Have you seen the new red line draft decision?
So I just got it the same as you, I just got it when I got here.
Perfect, okay,
So
good enough.
I have it, but I have obviously studied it or read it.
That's okay, all right,
I
all right.
have it.
As long as you have a copy, that's
I
great.
did, yeah, so
Okay.
I can follow.
Okay, excellent, all right. In that case, I'll sort of just open it up for sort of ongoing discussions and deliberations.
I have a question. The property is owned by an LCC. It's a Delaware company.
Yes.
And it's there probably for liability purposes, that three people own it and they're protected against any liability claims made against that parcel or that home, I guess. They are a corporation. Can the corporation occupy a house as a resident? Because we have residential requirements.
Well, you don't have a residency requirement for a dwelling unit. And so I guess I'm not understanding your question relative to the definition of dwelling unit. There's no residency requirement.
Well, if you're going to have like a boarding house, the resident has to occupy the house.
Yes, and my understanding was that the board had already determined that it was evaluating this as a dwelling unit, not a boarding house, because there's no owner occupancy.
Right, sorry, not to hijack your question. I think Ernie's just asking whether or not the legal proposition that a company can't essentially, if a limited liability company owns a house.
Yes.
And a particular use requires the owner of the house to occupy the house, is it conceivably possible that an entity could occupy a house as opposed to a living person?
Well, so theoretically it could be, because you could choose to define what it means to be an owner in your zoning bylaw in a way that would allow it. So for example, if you defined owner to include the manager of an LLC, then yeah, I mean, if the manager of the LLC was living there, it'd be owner occupied. It's really up to how you define that term. So it's possible.
Right, but presumably if the term, if the term owner is not defined in the bylaw, then essentially the board can.
Wait for an hour and a half, 2 hours. Do you want to leave?
Yeah.
Wait,
I guess I
Lenny.
can come back later.
Lenny,
Oh, I'm sorry.
no, that's okay. You can just put yourself on mute if you need to have a side conversation.
Oh, I'm sorry. Yeah, okay.
That's okay.
Yeah, I mean, so you as a board sit in the shoes of the building commissioner, who in the first instance is the zoning enforcement officer. And one thing that the zoning enforcement officer is charged with doing is interpreting and then applying the bylaw. So yes, if there are terms in the bylaw that are not defined in any sense, then as a board, when something makes its way to you, you are responsible and have the authority to interpret that term. So to answer your question, it's possible. I don't think your bylaw is interpreted owner that way, which again is why it was my understanding that the board had already said they were not gonna evaluate this as a boarding house use.
Okay, so the building commissioner at the time, he can make that determination.
Yeah, so the
That's his
building
choice.
commissioner in the first instance interprets and applies the bylaw as the zoning enforcement officer. And then under Massachusetts General Law, Chapter 48, Section 14, when an appeal comes to you, you act with all of the same authority as the officer whose decision you're reviewing. So you act with the same authority as a board.
I do have another.
Sure, go ahead. That's what I'm here for.
This is just a free for all. I'm not gonna call him.
I'm concerned that anybody can basically be incorporated as a sober home operator. And the state, they have to meet no requirements. Anybody could claim it and say, I'm a sober home, therefore I can use the home any way I basically see fit, because we have no control over it.
So there are, as you are correct, there's voluntary association in Massachusetts for sober homes. There's no specific regulation or requirement for any kind of registration or licensing of sober homes. It's entirely voluntary process. You know, under your bylaw, there's a definition of dwelling unit, and it almost, in my mind, doesn't matter if it's a sober home or not. If it's being used consistent with that definition, it can be a dwelling. But yes, you are correct that there is no formal regulatory.
And we actually have no control over it whatsoever. If they move in and say they meet the 5 requirement, they can basically do anything they damn well please.
Well, I mean, I wouldn't say.
There's no control.
Well, from a zoning perspective, both under federal and state law, individuals who are in recovery are considered disabled, and they are protected under the FHA, the ADA, 48(3), 151B, all of our discriminatory laws. And at least one case, the Massachusetts Appeals Court has said that those same extensions apply to the homes. And in fact, I think if you look at most of the sober home cases that we've talked about that are out there, it's actually the homes bringing the cases, and courts have said that the operators have the standing to bring those cases. They have that same legal authority. And so, you know, that's the whole point. The whole point is that the law says that folks in recovery have a right to live within communities and integrated into residential neighborhoods.
Even though the home has to meet absolutely no requirements.
I mean, unfortunately, that's the status of the law. But you're correct. It's a voluntary process.
Can I add something here, you know, in terms of the ownership issue?
Sure.
Yeah, I mean, basically, you have an owner, which is you know, this limited LLC, and they're renting out to these residents. And I don't see how that's any different than, say, a major company that owns a home and rents it out to individual residents. I mean, it's the same kind of legal relationship. There are apartments that are owned by big corporations, and they rent out to individual tenants.
They can do that, yes.
And I would tend to agree that the ownership is not what determines the use. So it doesn't really matter if it's owned by an individual or a company. The use is residential. And that's what it comes down to. And I know, you know, it's frustrating at times, but yeah, I mean, you can have a venture capital firm buy up an entire residential neighborhood and rent out all of the homes. And as long as they're being used within the definition of residential use, they're residential use. It's not about the fact that somebody's making money off of them and not just being a landlord. So the use is residential.
Maria has her hand.
Oh, I'm sorry, thank you so much. Maria?
Yes, I just wanted to point out that there is a difference in just that if there is a corporation that is owning the house and renting it as a single family, it can only do one lease. It can rent to, so let's say it's students, it can rent a place to 5 students on one lease. But if one student decides to go away, it's like the whole lease is at risk, if that makes sense. It's not allowed to take a single family and do 5 separate leases, as in rooms. That would be essentially subdividing the property without the town's permission.
But at the same time, you could rent to 5 people without a lease, and it could be tenants at will, and there wouldn't be any lease at all.
No.
Yes.
As soon as you pay rent, you've created that tenancy.
Yeah, you've created a tenancy, but without a lease.
Right, but I just know on the landlord end, there's a big deal about that. Like we're not allowed to subdivide properties within them. it's not subdivided, so to say, but they're not separated. They're one unit.
Well, it's not subdividing if you rent to 5 individual tenants and each tenant is a tenant at will.
No, you're not allowed to do that.
Yes, you are.
We
And
aren't.
wait, who are we? I mean, you can do that in Massachusetts.
Okay, well, hold on, let's just pause right there. Town council wanted to make a comment.
Well, so I'm not gonna get into the landlord-tenant law side of this. All I can say is for zoning doesn't care about ownership. Zoning doesn't regulate forms of ownership or how you own things, condos versus apartments. That's just not something that zoning gets into. You have a definition of dwelling unit, that's what zoning cares about. The point I was just trying to make is that this is a residential use, regardless of being owned by a corporate entity. That's all.
The difference would be
Just-
that.
Just
One
to
second,
finish
Oh, is
the
there,
point
no,
that I'm
sorry,
trying
go
to say, sorry,
Please.
oh God, sorry, I'm terrible with Zoom.
No,
Yeah,
I
just
know,
the-
it's
the
awkward. I
difference
realize
of-
it's, please jump in.
Okay, sorry, I didn't hear that. Just the difference between, you know, the homeowner or somebody there can take on boarders and roommates in a different way than a corporation or landlord that owns the property and doesn't occupy it, if that makes sense.
Okay. I think the one dividing line, I think, you know, I think what you're trying to say is that if a sober home, and I'm gonna use that term loosely because I've yet to actually been given a definition of what that means, is if they were providing, for example, like day services, like someone shows up, you all have meetings together, whatever, and then you leave and you don't actually live there. Like that essentially would be the difference because that's not residential use.
Yeah,
Because
that's
they're not actually
Right.
living there.
I
You
mean,
know, it's akin to a therapy.
Sure,
You know,
yeah, I
service.
mean, if it's not being, if no one's living there, it's not residential. If
Right.
folks are living there, it's residential, and that's the difference. Yeah, absolutely.
Other questions, comments, for council that could be helpful? I didn't know if you, I didn't know if you want to.
That more, I think she answered it.
Okay.
So it's just, there's no control over them, and then anybody can basically come in and say, hey,
You could run one yourself?
that's right, maybe I'm retired, maybe I should start that. All kinds of therapy provided.
In terms of additional comments or questions,
Please.
what the draft doesn't deal with, and we have discussed it before, is what, if any, role we should ask the building commissioner to get involved in this situation.
Yeah, so this is, well, sorry, Lenny, I was gonna hijack your question, but before I do, I wanna make sure I actually understand it. Cause I might be taking it down a different road than that. Are you asking what role he might take? Are you talking sort of generically? Or if we're gonna ask something at the end, whether he has a role versus what our role is? Is that where you're going?
Yeah, the latter. In other words, are we going to ask him to play a certain
Yeah,
role?
and actually, that's a question for me, which is if there is to be an ask of the property owner, I guess this is where like section 14 kind of comes, I believe it's section 14, comes
Yes.
into play, where essentially we have the authority to act in the essentially in the shoes of the zoning enforcement officer, the building commissioner. If an ask is going to be made of the property owner, is that something that, just from a purely practical perspective, do we do it directly? Do we have to ask the building commissioner to do it? And if it's the latter, are we asking or are we ordering? I'm trying to figure out how to physically go down those roads.
I wasn't, this is an area of the statute, there's very little guidance in it. I mean, this
That's
doesn't
the
come up-
question.
Yeah, so it doesn't come up a lot, right? And so what we generally say is, again, you act with all of the authority of the building commissioner. So absolutely, I think that you can order or direct the owner or the operator to do something, just like the building commissioner could have. When it comes to the building commissioner, I think it's more of an ask than a direct, right? And I think that's kind of the way we look at it generally, given the language of the statute and just the roles and, you know, the way it works. So for example, I had been asked to provide some language,
Right.
and I did, where, you know, and again, it depends on how you shake out this, like, for example, if you ultimately find, you know, that, yes, a sober home could operate in a dwelling unit, but whatever facts you have, you find there's, you know, a reason for zoning enforcement, then you might order something, you know, along those lines. You might find that it can operate and there's not a reason for zoning enforcement, you might order something different. So I think limited ability, for example, you could say, we uphold too much of the decision of the building commissioner that says this may be a boarding house or a dwelling unit. However, we find based on the information before us that there are more than 5 people there, and we're ordering the applicant to cease and desist, you know, operating in violation. That, or you might say, we don't find there's more than 5 people. And so some of what you order is gonna depend on ultimately where you come out with your decision based on how you apply the facts to the law. But I certainly think that you could order the applicant, if you find there's a zoning violation, you could certainly order that to stop. I think that, you know, you could say, look, we don't have the evidence to find there's a violation, but you're in a tough position because the operator hasn't participated, and it puts you in a really tough position. You have an applicant with a burden of proof, you have to weigh this information, you have nothing from the operator, and so I don't see why you couldn't, at a minimum, still say, we're ordering the applicant to provide the building commissioner.
You're the owner.
What's that?
The
Or the
owner.
owner,
The owner,
yeah, sorry, the owner, usually it's an applicant.
I understand.
But that you're ordering a level of proof to be provided to the building commissioner that in fact, factually, this is operating lawfully within your definition of dwelling unit, just as an example.
So let me play that one out.
Sure.
So that happens. Copy is sent to everybody in the world.
Yeah.
30 days goes by, crickets.
Yep.
We cannot, obviously, we don't have power, like any sort of administrative, like traditionally, as quasi-judicial body. We, you know, we're not about to start pounding on doors because we physically can't do it. So does that essentially fall back under the building commissioner? That he then, it's essentially up to him to decide what might be the next step to take?
Yeah.
Because in his mind, he would say, well, there's been an alleged violation of a zoning board of appeals order.
Mhm.
So now I have to decide what's.
Exactly,
Okay.
yes. Yeah, because it's in here, it's in order, and if it's not appealed, it's final and it was supposed to happen.
Right.
And so that in and of itself is an issue, so yes.
So the
So if I-
appeal
so
was approved.
Go
Oh,
ahead.
sorry, Lenny, 1 second.
So anybody aggrieved by the decision of the board can appeal it. So, you know, certainly the applicant would make the case that they're aggrieved if they're unhappy, but certainly the owner or the operator, I think, would also have, you know, an ability to appeal it, you know, and challenge whatever's in it. And I do think if there's anything in here when you're ordering the owner or the operator to do something, then more than just being like, here's a copy of what we filed, like, it should be noted then, you know.
Of course, right.
This is what we decided, and by the way, we told you to do this, should be clear to them so they see it. But, you know, I think really anybody on either of those would, you know, have an ability to take an appeal.
And from a timing perspective, so it's what appellate rights are 21 days, right? 20 days, sorry. So.
After it's filed with the town clerk.
Correct, okay. I'm just thinking from a timing perspective, so that any request of the owner would have to, it would probably make most sense to trigger the same X number of days after the order becomes final and unappealable, because once they miss the appeal window, like, there's nothing that much that they can do at that point.
No, and that's up to you, how you guys
Right,
make it,
understood.
but it's 20.
Yeah.
It's up to what you wanna do,
Right,
Yeah, but once we've issued the order, though, we're out of the picture totally, right?
unless something,
There's
unless
one
it's new
building
application.
commissioner, unless it's appealed.
right, unless it's
Yeah.
appealed.
It's appealed.
If it's appealed, yeah,
Yeah.
then.
But other than that, it's the building commissioner to enforce
I
what we
think
said.
I think it's fine within your authority to say, give the information to the building commissioner, who's
Yeah.
the zoning enforcement officer, and let it go that way. I think that's fine, but again,
We don't
there's
upset
almost
him.
no case law in how that gets used.
Right.
I don't think we want to upset him anyway. He does a good job, so.
Are there analogous situations where, because I'm just, it's an odd scenario in terms of the burdens, you know, in terms of like the application and whatnot. And I guess I'm just trying to understand is there an analogous situation where a property owner has to prove compliance, not counter a violation, but prove compliance? Does that make sense?
Yeah, I mean, the thing is, you know, it's a good question, because again, when we're talking legal burden, if you're seeking zoning enforcement, the burden is on you.
Right.
But I don't think that that means that the building commissioner can't just say to somebody, hey, this question's come up, can you give me some information so I can make a decision?
Yeah.
You know, I don't think that ultimately you can avoid having, you know, your use be evaluated or zoning by just like refusing to cooperate. Or, you know, to participate in the conversation or what have you. So, like I said, I mean, I sympathize with you guys are in a tough position because it is unusual, at least in my experience, to have the subject property owner not participate in it.
Lenny, I apologize for cutting you off before, but I think you had a question or a comment?
Well, actually, I was just trying to get a clarification from what Robin has said. If I understand it correctly, in other words, we can demand something that, in terms of enforcement, as a zoning board, but in terms of the building commissioner, we can ask. Is that the distinction? In other words, we can't order the building commissioner to do something.
Yeah, I would say your ability to order is directed at the property owner or, you know, the user, what have you, but when it comes to the building commissioner, we generally take the position that it's a request.
And ultimately, if the property owner actually did provide, you know, some response to whatever we're doing, it's the building commissioner's discretion.
Yes.
As to however he's interpreting it or whatever it is, you know.
Could we just start preliminarily with an ask of the building commissioner, and then based on what occurs, if we're not happy with what's found, then make a decision of an order to the sober home?
I don't think we can do that because
the logistics.
Well, from a jurisdictional standpoint, we lose jurisdiction over the matter once it goes back to the building commissioner. We can't retain oversight over the building commissioner.
Well, once you render the decision,
It's done. The only way it comes back to us is if there was a new case or an appeal or something like that.
Yeah, and honestly, I think that you know, your building commissioner doesn't really have the ability to get the information on their own. So without some directive from you to somebody, I don't know that you ever get that information. But yes, once you file your decision, you don't have the unilateral ability to bring things back. I mean, you could discuss it at a meeting and make further requests to the building commissioner. You could ask things, but you don't have the ability to order or direct or change a decision or anything.
Right, like we could ask the building commissioner, hey, in 45 days, please provide a report, you know, we could ask a report as to if you heard anything or not, you know, I mean, he could choose to ignore us. He wouldn't do that, of course, but that's probably the farthest we could go is just to get information.
So in other words, it can't be a conditional kind of situation where if we don't get step A from the building commissioner, we can resort to step B. Okay, I get it.
Yeah, we got one shot, and either it's not if A then B, it's A or B.
Well, it also,
Or
again,
and-
someone is gonna
yeah.
depend on what you decide.
Oh, no, I understand. I mean,
Right.
we're talking hypothetically.
Yeah, but for example, were you to decide that, you know, there's more than 5, there is a violation, and you order a cease and desist of that, it might play out a little differently than ordering information to be given.
Right.
So some of it depends on ultimately what decision.
So this might be abstract per se. In the normal course of events, you have a neighborhood and there may be a rowdy neighbor in the neighborhood and some action could be taken presumably by the police department if whatever is happening at that particular location. Is that same concept applicable if we find there's similar behavior going on in this kind of environment?
So I can't speak to,
I know, it's.
honestly, I
off the
can't
cuff,
answer
Yeah.
for you how the police department would handle any particular situation if they got a particular call.
Could they respond in kind, per se?
In-
So if you've got this situation going over here, that's a rowdy party, and there's an equivalent rowdy party,
Yeah, I mean,
can they perform their duties accordingly?
yeah, I mean, just as you need to treat the use equally.
Yeah,
as
yeah,
the
right,
use, I would presume they would do the same, but I can't speak to.
Yeah, I'm not
the
asking
law
you
enforcement.
to, I'm not asking you, I'm just
Yeah.
kind of teasing it out a little bit.
Stow or Michael, if you have questions.
I don't have any outstanding questions.
Unless there's anything else specific for town council right now, I'm inclined to sort of dive back into the decision. And if we have questions as we go along, we can just ask them. If council has comments, of course, we welcome them, same thing, Val and Michael as well, so.
So before we start, what this opinion?
That was my question.
Oh, okay.
Yeah, those were
Yeah, there
Ernie's,
was, okay.
Ernie's comments.
Right.
It wasn't clear.
I think about forming a company.
Yeah, there were topics for discussion.
Yeah,
Things got
okay.
slow.
Recently.
Yeah. All right, if there's no objection, I'm sort of, Frank, I think this is just to go page by page, section by section, as we did last time. We might be able to fly through certain parts and go slower on others, so. All right, page 1. Any concerns, comments, edits? And if I hear none after the point of time, I'm just gonna move on. I think that is okay, so. Okay, page, we'll do this by section. Sections 1 and 2 are okay. Let's take a look at section,
Mike has some suggestions for that wording.
oh, yeah. Yeah, I mean, I'm good with Andy Demore's revision.
Is that the one that says, although not required, neither the owner of the property or representative attended the public
No, the
hearing?
second one.
Yeah, mine was the top and Andy's was the one below it.
I don't see, I don't think I see one below it.
There's a red line.
It's the red line comment on the side.
It's in the same box. It's in the same comment box.
You know, I don't think my draft has any side comments on the bottom.
We've got the same thing happening.
Go into show comments, and go into review and click on show comments.
Here, or all
Sure.
markup.
Yeah, the all markup rather than the simple markup.
Yeah,
Show comments.
Because I'm viewing it in the browser. One sec.
Yeah, don't ever view it in the browser.
Open it in Google Docs.
Technically, it's Google Docs, but
So this should be the version that Michael sent out at like 5, I think, this afternoon.
Yes.
Oh. Okay, so I have to go back and see if I can get that by email.
Let me know when you got it.
Let's see. Docs, let's see. Let's see. Try this. This is comments, Michael Slagle. No comments from Michael Slagle.
No, that is Michael's annotation is the comment by Michael, but in the annotation, there are 2 different renderings.
If you have to catch it, just read them out.
Yeah.
Yeah.
Oh, that's fast.
Michael could also share screen.
That might be
Whatever
the
works.
easiest.
You want us to just put it up on the screen?
Yeah, would you? That'd be good.
Great.
Just a quick question. When it's saying the comments, are those like the inline red lines or are they separate?
Yes. Yes.
They're on the
It's the
side.
inline red lines.
It's on the
It's on the
sidebar.
side.
It's the
It's on the
track.
sides.
So there are inline
Okay,
edits.
I got it now.
Also, it's on the
Okay.
sidebar. There you go.
Okay, is it the one that says, although not required, the owner of the property or representative did not attend any of the public hearings? Is that the one?
That's the one that's on the side, the lower
Yeah.
one, is AD,
If you also look,
AD version.
if you look at your screen, Michael is sharing it as well. Can you see your screen?
I see is like a purple box here and it says, the AD version, is that it? Yeah.
Perfect,
Is-
excellent, there we go. All right.
Oh, good. Yeah, I got it. Good.
Okay, so back to the original question. I'm fine with Andy Demore's, which is the AD version. Does anybody have any concerns with that version?
Nope.
That's good.
Excellent, all right, we'll accept that. All right, that's section 2. Section 3, just a list of correspondence. I think we hit everything, but just be good with section 3?
Yes.
All right, good. All right, moving on to section 4, which is the findings. All right, number 1.
I think we should put zoning in there, that we have, town has 2 bylaws.
Sorry.
The zoning bylaw is one of them, and the other one's general bylaws.
Earlier in the document, it's shortened as bylaw,
Okay,
just for reference,
Right.
so I can go back and delete that.
Still zoning bylaw, short to be bylaw.
okay,
Yeah, no, that's the, no, I think the
I
way
didn't-
you positioned it is the correct way.
Okay.
It's just simple way. to put it
Yeah.
out.
okay, sorry about that.
No, you're good.
Yeah.
This is a tricky thing on number 1, the slash between commission and zoning officer. You either need a space on either side or no space. Sorry. All right, anything else for number 1? All right, finding number 2. Finding number 3. Okay, so I think there's a comment here about the drainage flag, so I think that's been taken care of. Anything else with number 3? Oh, the last sentence of number 3, the word property needs to be capitalized, just for consistency.
Yeah.
Finding number 4. I asked, was this before it shifted to LLC? The property was sold to 3 individuals in August, so it was before the LLC was even on the operator. So sorry, when did it become the LLC? That was in December. Oh, okay. So just to circle back around to the discussion that we had the last time. So in the second sentence of number 4, it's a definitive after this transfer to sober living home began operating at the property. Do we want to,
Put dates on it.
well, no, I was going to say, I don't think we have a definitive date, but I'm saying, do we want to massage it, say like it is believed or it has been represented? Because we say that later on. If people are okay with it, then fine with it as well. I'm not sure, someone
So where do you wanna make that change here?
I'm not suggesting, I'm just asking, because I know there's a back
Yeah,
and forth. So number 4,
Yes,
the property was sold in September 2025 to 3 individuals.
yeah,
And by the way, is it supposed to be August? Not September. You have a comment in there.
It was August was when they transferred it, but wasn't recorded until September.
Oh, okay.
So
Yes,
it doesn't matter, but
the September dates wasn't a deed.
Okay.
deed was September.
After this transfer, a sober living home began operating at the property. I believe later in the decision, we had said something along the lines of, it's been represented that a sober home is operating at the property, which is slightly a more nuanced sentence. So my question is that, do we want to be consistent with that phrasing, or do we want it to be more definitive,
No,
yeah, I think we have to be,
we don't know.
just more nuanced? Okay, all right, so for after this transfer occurred, how do we say it afterwards?
once the transfer occurs,
No, that's not the part.
what's the word you're looking for?
Like, let me say, like, it's been represented that,
Testified that.
No, it's not
we
testimony.
say it later on.
We took it there.
It's not testimony.
Okay.
In section 11, we say, based on the information provided, the property is represented to be used as a sober home.
You got it.
Okay, so for number 4, just to be consistent, after this transfer, it has been represented that and I think we're going with the sober home term rather than sober living home. Rob, is there a difference from your understanding between a sober living home and a sober home? I've seen, okay. just wanted to-
No, I mean, I was just gonna say, just for word.
Yeah.
If you want, you could say, you know, you could just say, it was represented to the board that after this transfer.
Yeah, perfect.
That's all, just to get,
Yeah, that, my phrasing is a little off. Are you good?
Yeah.
Okay. All right, any other comments on number 4?
Well, yeah, the second, next page.
Yep. Okay, the LLC should identify as,
Why not identify it with the LLC?
I mean, that's, so. What's that would be?
Okay, we just make those separate findings.
We'll make this subdivision. So we're dealing with 2 LLCs.
So-
One is the Delaware company, the other was the Massachusetts company.
So, I'm sorry. So the first part of your comment,
Is about the,
right, so where, so so where does that go in for?
put in parentheses or whatever after limited liability company.
So,
And just in place of LCC, put in 41 Birch Hill Road LLC.
oh, okay, so we can be specific about it, so the sentence would read, the third sentence would read, the property was transferred in December 2025 to 41 Birch Hill Road, limited liability company.
A Delaware corporation file number 1.
Yeah,
Yeah, right.
and we can still say afterwards, the LLC.
You really have to say limited liability in its entirety. I mean, that's
That's
essentially
the
what LLC means.
Well, once
No,
you
that's the title.
instantiate it.
No, you say it the first time. then you
Okay.
say LLC. I mean, don't get me wrong again.
Yeah.
So, okay, so that's that one.
And later on, I don't know exactly where he goes.
This is the second paragraph of the
Yeah.
comment.
Yeah, the second one is for the other LLC, the Engage Wellness Action LLC.
I don't believe that was part of the board's record, the information about that LLC, so I would just caution
The
about
name,
referencing.
the name was, wasn't it?
The name was, but the part that says their general character of business It's
Oh.
not part of the board's record.
Well, it's on the license.
I would avoid using things not
Oh, correct. It's on the LLC document.
Robin.
Yeah, but if it's not, what is it?
If it's,
I mean, was that something that was in the board's record?
It's either in the record or
it
it's
was
not.
not submitted as part of the board's record.
There was a comment from a participant.
There was
a citizen.
comments about that there is another LLC company based in Acton,
And the name is stated as well.
but the exact thing about the general characteristics of the business was not submitted to the board. It
Or
was
their
just,
identification?
or their identification number. So
The state has that information. And it's available online from,
Yeah, but I think there's a distinction between what's publicly available and what's actually been presented. I mean, I understand the point. I was just thinking back, there was a butter, I can't remember his name, in the second public hearing, who was going into all that. Problem is, I just don't remember this off the top of my head. I can't remember the specifics of what he was talking about. I mean, one way to deal with this is the name was definitely identified. I think that's clear.
it was.
Yeah, so at a minimum, we could say, based on the information provided during the public hearing, it appears that the sober home, actually, it should be that the sober home, the sober living home, is either being operated by the LLC or another corporate entity that is affiliated with the LLC, parentheses, and then put the name in there. Or however, which has been identified as, that's a better way of putting it, as Engage Wellness Action LLC. And then I have to go back to the record to see what the last part, I just don't remember what that gentleman, I can't off the top of my head remember what that gentleman was talking, what specifically he said, because he was providing a lot of information, but.
Yeah, he presented himself as having been a consultant for years. And
Yeah, right, that's the guy.
Right.
Yeah. Anything else with respect to number 4?
Well, I'm just going back to the first comment, the first change. The ZBA has not been provided with any information as to the general nature of the business. I mean, is that accurate? I mean, we know it's a sober home.
Sorry, which item are we?
So the comment that is Michael's M6.
Oh, the second sentence of the first paragraph of the side comment?
Yes.
But we weren't provided any information by the operator.
Except his representation that
Correct.
they're operating out of the property.
Right, that was the only
Yeah,
indication or reference that we received, so. So, and when you had that thought, what was your thought there about?
there's two LCCs we're discussing here, and I just wanted to identify what they were.
No, but you made a comment here that says has not been provided with any information. From the LLC.
The only
correct.
information we have is off the corporation form from the,
Right,
and that gives you what the purpose.
I got that.
Is. That's stupid thing.
I think the problem here is when you say the general nature of the business, and then you go on to talk about its legal entity. Those are two separate things. I mean, the general nature of the business may be to operate a sober home. The way it's set up, which you refer to in the second part of the paragraph, is that it's incorporated.
Yeah,
Those are two separate thoughts, two separate concepts, really. The general nature is the purpose. The second part is the corporate entity.
yeah, I think the suggestion was just to include the first part and not the second.
In other words, leave out the incorporated part, assume to be incorporated.
Yes.
Okay. Okay.
All right, are we good to move to section finding 5?
Yep.
All right, finding 5. Any questions, comments, proposed edits? All right, number 6. All right, number 7. So Bernie has a comment here, which LLC the building commissioner talked to. So the
He's talked to 2 of them. He's talked to both of them.
so
I believe so.
so February 2026.
I assume this
Which
is the
is-
homeowner.
Correct, that's Nick Diamata's.
Yeah.
And so when it says to a representative of the LLC was previously defined as the folks who are the owner.
Okay.
So I think we're okay there.
And also, there is no document from the owner that formally makes that a commitment to the town that the sober home use will be terminated or that the property would be rented to a single family. All we have is this word over the telephone to the building commissioner.
Yeah, it was really just a conversation.
Right. So I'm just saying, we don't know what they're doing with the house for sure.
Right. Thoughts on the last sentence?
I think it's represented in it already, but I can adjust based on that suggestion.
Yeah, I mean, essentially, the way I read.
I just want to point out that we don't know for sure, even though they haven't provided the document.
Oh, no, I know.
We only have the verbal.
Yeah, what I would suggest
What's
is,
happening.
I think I wrote 7, so that's why I'm saying that. I think that's where I was going with the last sentence, essentially that no written confirmation has been received. I have no problem essentially replacing that sentence with this one.
I would just I wouldn't use the term commitment because they're not obligated necessarily to provide us.
There's no document from the owner that formally. There's no document from the owner. How about, there's no document from the owner that makes this representation, okay, to the town. How about that? Okay.
Or how about confirms his verbal statement?
I'll take that one. That's a better one. Yeah,
Should we remove single family, just because it could be rented to another,
We don't know what it's going to be rented to.
single family, it's not necessarily true that it needs to be rented to a single family.
He gets so
That's
rented.
what it said in the email.
That was the words of the building commissioner, not the applicant.
I wasn't quoting
Right.
it.
Plus he could rent it to a sober home.
I mean, I'm fine saying renting it to a family, that's fine. So we'll delete the last sentence. And then simply put the Bernie suggestion in with the change that Andy Crosby suggested. Delete the word single. And then we'll just have to make some of those words capitalized. Okay. All right, anything else with respect to proposed finding number 7? All right. Proposed finding number 8. Here we go. Number 9. Just a small typo, if you can just put a comma between chapter 48 and section 3. Sorry. All right, proposed finding number 10. The word safe should need to be added. I believe so.
Right.
Lenny, why don't you go first?
Okay, my comment from the previous meeting, but I would still say, in addition to the ADA and the Mass Fair Housing Law, that also under the Equal Protection Clause of the 14th Amendment to the Constitution.
I don't think it's necessary. I mean, it's represented. It's state and federal laws included.
The other ones take care of it quite well.
So,
The other ones specify in more detail what's required. The laws.
all right, because this was left as an open item, I'll just flag it. The second sentence in number 2, the one that then refers to safely and sober homes case.
And I know you were looking for, I can tell you what the case says, and you don't have to put in anything in particular, but the case says the Federal Fair Housing Act prohibits discrimination in housing based on handicap. Persons recovering from drug and alcohol addiction are considered to be handicapped persons under the statute. Owners of homes housing such residents are also protected under the FHAA. That's the direct quote. So everyone has it, because I knew you had a question about it. What do you want to put in the decision, it's totally up to you, but that's the direct quote.
The only change that I was going to make was someone protected regardless of the fact that the summer home itself may be owned by a commercial entity. I don't think we need to go into the operation of simplify it, but just simply saying owned by a commercial entity, or not a commercial, a corporate entity. I think would be better. Sorry.
So by an entity and as a commercial enterprise, or?
No, sorry. It would read, similarly protected regardless of the fact that the sober home itself may be owned by a corporate entity. Any other questions, comments on number 10? Okay, a lot. Andy, I think this was your comment.
Well, there's 2, one's from Mary and one from me.
Yep.
One's you and one's from me, right?
I like Andy's.
Where is it? Yes.
Other thoughts?
Mm-hmm. I like Andy's, and I don't mind what Mike put in there also.
We can square those. So I have a couple thoughts. One is the way number 4 got sort of reworded. I think we should mirror. The point of 4 was to be closer to 11. Can we mirror now do the reverse? Because I like the way Robin put it. It just was cleaner. I think it was like I think
Oh, that was the,
Yeah,
my notes are a little messy, it's been written.
it has been represented to the board.
Been represented to the board as a sober. Yeah,
Okay,
I can,
here, so for 11, it could be based on the information provided. It has been represented to the board that the property is being used as a sober home for individuals recovering from addiction. I think makes it sound like more readable English. What I might suggest is, Annie, I don't know what you feel is, can we take your part and just make it a different, as a separate finding?
Sure,
Okay.
yeah.
What I might suggest though is to say, just to pair it with the sort of the cautionary language from Michael, is to preface it by saying, although the board acknowledges that it is not required,
Correct, yeah, sure. That's fine.
you know, comma, based on the information provided to the board. Sorry. So the new 12 essentially would be, although the board acknowledges that it is not required, comma, the board is unable to determine if the property is certified with MASH or if the MASH code of ethics is being followed.
Good.
So I have a question, last part. Does the knowledge that they follow the code of ethics actually important here? Does it make any change in terms of our decision or whether or not it's a sober?
I mean, for what it's worth, I don't know if it advances the ball in one way or the other. At the same time, you know, to the extent that we want to note, I don't think it makes a difference one way or the other because at the end of the day, as we all know, it's not required. I mean,
Right.
Ernie could open up a server home tomorrow. I think you're planning on it.
I'm going.
But I mean, to the extent that it's a known fact, I don't think it detracts from anything as long as we put Michael's sort of cautionary language in there.
Yeah.
Yeah, but you're right. I mean, whether they're doing it or not, you know.
Yeah, I mean, it doesn't hurt, but at the same time, I just wasn't sure it's adding anything.
So.
I'm not objecting, so.
Yeah, no, it's a fair question.
So,
Okay. Good. Okay. Anything else with 11 and then what we'll describe as 11B for the moment? Okay. I'm just gonna put these in a group. Proposed findings, 12 through 17. Because these are largely just reiterated definitions. Though, as I put 15 together, I just want to make sure people are okay with that one.
There's capitalization there, dwelling unit in 15.
Which one is that?
Okay. Any other comments or questions about numbers 12 through 15?
15.
Good.
Okay. 18.
Very good. I think we already got the answer to that, right?
Yeah, I think that might be dealt with in a different section. Yeah, this Ernie's comment's gonna be addressed in 22. So I think there's an incident, you know, very tricky thing, there's a space in front of the quotation mark on 18. All right, anything else on 18? 19?
So can I just add one comment on 19?
Sure.
Because I think, I may have introduced some confusion with that one, but I had watched all your videos and I was trying to, get everything in for discussion, but, when you look back at 13 at the definition of dwelling, the concept of transient only comes up in the context of a commercial accommodation for transient occupancy. So if the board is satisfied this is residential, I don't think you need to get into the transient in your decision because transient's related to commercial in that definition. So I'm just throwing it out there for discussion.
Okay,
And maybe something you wanted to get rid of, it's up to you.
okay, that's fair enough.
But again, I had watched all your videos and was at one meeting and was trying to get everything I could in for you to talk about when I was asked for comments.
You get brownie points for watching all your personally, I'm okay with keeping 19 just because of the generic nature of it, if you all are okay with it.
Not if it's, if it only pertains to something commercial. I mean, we're not dealing with a commercial situation here, so I would strike it.
Yeah, it does appear in the definition of dwelling,
Dwelling.
but not in commercial accommodations for transient occupancy, trailers or mobile homes.
Right, for commercial occupancy.
But it's in the definition, that's all I'm saying. So it doesn't hurt to have it in there.
Yeah, I mean, I think this is akin to a few of the other comments that maybe, I don't think it might fall in the category, it doesn't hurt, but doesn't maybe necessarily help. It's just,
See, I think it's suggesting that we're considering this residence to be a commercial entity by even mentioning it.
well, I think part of me would be inclined to put it in there only because also there was significant discussion during the public hearing with respect to it. So I think acknowledging it, I think might be worth it, but sorry, Andy.
I was thinking maybe add the sentence saying the board recognizes that transient the dwellings do not have a limitation on transients or something to that effect. So basically acknowledging that it's not applicable to a dwelling.
We agree with that.
The bylaw for a dwelling does not.
How about we say this, acknowledging that the definition of dwelling unit does not include the term transient, comma.
We spent a lot of time with this. Where we are again.
It's fine the way it is.
Yeah, I would say just leave it alone.
I like either David or Andy Crosby's definition of saying, although it does not apply to a dwelling. And then putting the rest of the clause, the board interprets transient as akin to a short-term rental type of use.
Comment that it was discussed in detail.
Yeah.
Or we recognize it's not applicable.
Yeah, I'm fine with leaving it or adding further definition there.
Should we take a vote on it?
I think that's necessary.
It did come up a lot, so it makes sense to keep it.
That's my point.
But it doesn't really pertain to the situation we're dealing with.
Yeah, no, hear that too.
So, I mean, if we put it in, but we just state,
How about this? How about this?
Go ahead.
While the board acknowledges the manner in which the term transient is used in the bylaw, the bylaw does not define. And that's broad enough that it hits all the marks.
So,
So while the board acknowledges the manner in which the term transient
Is used in the bylaw. Or, yeah,
in the bylaw,
comma, the bylaw does not define. Or whatever the sentence. You can pick the sentence.
Problem with that is the second clause, when it talks about short-term rental, can imply that it could apply to this kind of rental.
I don't agree with that.
You don't agree with my interpretation of it, or what the result would be?
No, I don't think we're implying that it does. I think we're just simply acknowledging that we're acknowledging the way.
Can I make a suggestion, just to maybe help?
Sure.
Oh, and you disregard it, but, you know, I don't feel that you need to offer an interpretation because of the way the bylaw is written, but I get that you want to acknowledge, because there's a lot of discussion about it, so I mean, what if you just say, the board acknowledges the manner in which the term transient is used, and notes that the bylaw does not define transient, period.
Okay. Yeah.
I mean, I'm fine with that.
Yeah, I'm fine with that.
so is that replacing all of 19?
Yeah.
Or
Yeah.
just all of 19?
You go with that?
Yeah.
Yes, all right. We don't need to. Okay. All right, 20. I think there's a comment here, that'll be addressed in 22.
correct.
Any other questions, edits on 20?
Well, on this thing about a boarding house cannot be occupied by a corporation.
That's, we're gonna deal with that in 22.
Oh, all right, okay.
Anything else in 20?
Okay, now.
Okay, 21.
And second, we have capitalized owner.
Oh, yeah. Good point. First,
Have we been capitalizing on?
I thought we had,
We have in another instance where we allude to it that way.
yeah, I think the word owner is capital. Oh, you know what? Well, can you just make a note of
Yeah, so was,
whichever we pick, let's just stick with that. I think we switch at one point.
yeah, we did.
Anything else with 21? No, okay, 22.
Again, this gets into this whole idea of owner and corporation, and even a boarding house could be owned by a corporation, and as long as there's according to our bylaw, no more than, as long as it's occupied by somebody that owns the property, it's still an okay, acceptable boarding house.
Right. So I'm sorry, so what's the concern about 22?
I think it was Ernie's comment, a boarding house cannot be occupied by a corporation, therefore they are not permitted.
Right, so are you suggesting we should say that explicitly?
I'm saying we should not put that in.
This is just making the declaration.
Sorry. Not put one in the statement that Ernie was suggesting, or not put in 22?
Not put in the statement Ernie was suggesting.
Oh.
Otherwise, 22 is fine.
Essentially, the question is, do you take it kind of like it's the intermediary, like, this is the conclusion. Your sentence almost goes above it.
Yes,
So, I mean, from my perspective, whether we have it in there or not, I agree with the conclusion.
okay.
So, but
It's fine the way it is.
okay,
So, but it makes a statement. Just going through it, I was questioning whether a corporation could be an option.
yeah, it goes from, it's basically 1, 2, skips 3 and goes to 4, and, yeah. Okay, I mean, if we're fine as 22, I'm fine with that too, it gets us to the point where I think we all agree. Okay. Anything else in 22? 23. Okay, that's fair, yes.
Right.
20, oh, sorry. Maria, go ahead.
I just said right. Yes, agree.
Okay. 24. Let's take this sentence by sentence, I think. First sentence. Appealing the zoning enforcement officer's declination to pursue a zoning enforcement action, the applicant has the burden of proving the existence of a zoning violation. Lenny has a comment here. I would say that the applicant has the burden of proving the number of unrelated people exceeds 5 rather than the burden of showing uncertainty.
So that comment wasn't associated with that exact spot, it was just for that
Oh, okay.
entire finding,
Oh, okay.
so it doesn't.
Gotcha. Sorry, I didn't mean to jump in. All right, well, let's start with this first sentence. Do we have any concerns with the first sentence? Okay.
There was a different word besides proving. I think it was presenting or something, something vague, and I thought proving needed to be put in there.
Okay.
To make it
All
more
right, so we're good with the first sentence? Okay. All right, sentence 2. Based on the testimony and documentation submitted by the applicant and the public, there is uncertainty about the specific number of individuals residing at the property. Are we good with that sentence? Okay. Sentence 3. Based on the statements the board heard during the public hearing, there is reasonable evidence that appears to show there are more than 5 people living at the property.
I have a problem with reasonable evidence. I don't know if the evidence is sufficient or not. I mean, I would say there is some evidence, but I don't know if it's sufficient.
It says reasonable.
Well, reasonable would suggest that there's sufficient amount. If it's reasonable, then there's a
The
sufficient
9
amount of evidence.
The 9 beds is kind of indication how many are there.
Well, we don't know. 9 beds could mean a number of different things. I mean, they could be double beds for all we know. I mean, there may be. It's a basis maybe to investigate, but is it absolute proof?
Neither can the building inspector.
You can always change reasonable to compelling,
To what?
compelling. So it's not.
That there is compelling. That there's compelling evidence. You think there's compelling evidence?
I don't know, I mean, maybe I don't have those correct legal definition for those two, so.
I mean, I think compelling would be stronger than reasonable.
Okay, you're the lawyer, I'm not, so.
Well, I don't know. It's just words.
Yeah.
Only because it's been a point that, and Lenny, I'm not trying to push you one or the other, it's a point that you've kind of held true and fast since the beginning, so I respect that. I mean, Frank, I think if your position is that essentially we can't, no matter how you characterize the type of evidence, we can't get to this, is it fair to say that no matter how we characterize the evidence, you're not comfortable with the sentence?
The term reasonable, I'm not comfortable with it. A different word, a different adjective would be okay. There's some evidence.
What if you just said evidence?
You just say evidence.
Yeah.
What if you don't have an adjective?
Right.
Yeah, that'd be better.
Take out reasonable.
Can I change, just a small thing, based on the statements the board heard, I don't think I like the phrase the board heard, based on the statements made in the public hearing, it's more consistent.
Now the other thing is the word.
I guess to be honest, I I guess I don't like taking the adjective out. Because I guess because I'm comfortable sort of making an assessment of what was said. Also, to the extent that we're gonna make, and I know I'm jumping ahead, but to the extent that we could potentially be asking for certain things of the owner or making a decision, I think it supports that decision by indicating the level of persuasiveness that some of the evidence was presented.
Well,
I don't know. I'll open it
maybe
up for others.
I have a different opinion. In fact, I would put may rather than there are. There may be more than 5 people, as opposed to there are more than 5 people. We don't really know if there are more than 5 people. There may be, but I don't think we have definitive proof.
We're not talking about definitive proof.
Well, it's saying there are. When you say there are, that's saying there are. That's definitive proof. That's a definitive statement. There are more than 5 people.
I agree with Lenny on the point that the information we have is enough for going and investigating, so to say.
Yeah, there may be a basis for investigating, but to say that we have definitive proof, I think that's
We're
a
not saying
stretch.
that I'm not saying there's definitive proof. I'm just saying that there's evidence that there are more than 5 people living there.
You're saying that there reasonable evidence that there are more than 5 people in the one I have.
Yes,
unless that's
evidence. Yes, the sentence is the definitiveness is not the number. The critical phrase is the type of evidence that there is. It's I'm not saying that there are 5 people there. I'm saying that there's evidence of that.
Can I just say, if I read the sentence in this decision later, and it said that there's, evidence that appears to show there are more than 5, I would read that thinking you found there were more than 5. I'm just saying.
No, I understand. I mean,
like I would read that as an affirmative finding that you decided there are more than 5 people there.
I'll disagree.
It's your decision.
No, I understand. You're right.
I'm just saying how I would read that.
I understand. Yeah.
If I just read it and didn't have any context and didn't know it.
Yeah.
There is uncertainty about the specific number of individuals. Is there a synonym for evidence?
Lenny mentioned the word some.
right. And may. Some and may. And some and may are certainly, to Marie's point, a basis for further investigation.
Okay, well, let's break this down. Based on the statements made during the public hearing, which is just a phrase better. So are we saying there is some fill in the blank adjective with respect to evidence, or are we saying there is evidence?
Some evidence.
I'd rather not say some.
I wouldn't either.
I'd rather say nothing than some. Some
So
implies
either say reasonable or nothing.
some characterizes it and could be misinterpreted as saying there's less than
Right.
than something.
I would just say just evidence.
Just say there's evidence.
Take a
Reasonable.
based on statements made during the public
More
hearing,
than 5 people.
there is evidence that appears to show
There are more. There are
I'm-
more.
I'm comfortable with taking that out and saying, yeah, evidence, and especially with it says that appears to show.
If you use the word may rather than are.
How about this? How about we don't say any of those? How about there's evidence that appears to show more than 5 people living at the property?
That does it.
I think it works.
Your evidence
Yeah,
of-
the appears to show, I think, is
Okay, good.
There is evidence.
I'm not comfortable with that either. That's my personal opinion. I think that's still too definitive.
That appears to show is definitive? Seriously?
It appears to show that there are more than 5 people, yeah.
No.
We didn't get the whole edit.
No. There is evidence that appears to show more than 5 people.
Well, that's saying that there are more than 5 people.
No, it doesn't. It says it appears to show there's more than 5 people.
Appears to show.
More than 5 people. No R, no may, just appears to show more than 5 people.
Again, I still think it's more definitive, and I think it should be less definitive. I mean, I'm just thinking how an average person would interpret that.
I see Letty's point, but the appears to show is the part that makes me comfortable with the statement.
All right. All right, I want to take a vote on this sentence. Based on the statements the board heard during the public hearing, there is evidence that appears to show more than 5 people living at the property. All in favor, Andy?
Yes.
No, you don't get to vote.
Oh, okay, I didn't know.
Sorry, I'm sorry.
I thought you were looking at me.
No, it's okay. I did my glasses on, so I went blind. All right, Andy Demore.
I agree.
Ernie? Maria?
I agree.
Okay, Ernie?
Lenny.
Lenny, sorry.
I disagree.
All right, and I agree. All right, 4-1, that works.
Okay.
So there is evidence that appears to show more than 5 people living at the property. Okay, next sentence. Based on the statements the board, it should be, based on the statements made during the public hearing.
David, can I say that I don't know that you need this sentence now that you've kind of had the discussion about transient, because that's all this sentence goes, so I just don't need it.
Right.
You may be able to just get rid of this sentence.
So starting with the word based,
Yeah, and then just, it's up to you guys, but if you think about it from the other conversation, I just don't know that you need it.
Yeah, because if we're saying that this issue of transients doesn't apply to this kind of housing, then why put this in?
The one thing that comes up for me with keeping it in there would be the part that we're even bringing up boarding house at all.
Well, there can't be a boarding house, so
That's a fair point, Maria, though. I think because for what it's worth, by 22, we've dispelled boarding house as a potential use.
Yeah.
We've sort of we've crossed that bridge.
So I definitely get that, but just meaning kind of keeping it in there in the sense that of the building commissioner historically, where it wasn't necessarily clear between boarding house and dwelling. Yeah, it just feels like that could be a reason to keep the transient part in.
No, I get your point.
in fact, we'd have no control how long they reside on the property. It's whatever the sober house operator decides their treatment requires.
So we were adding that to maybe qualify the previous paragraph or sentences. Could you just break it out and make it a separate declaration as a finding?
Okay, for current purposes, let's pull out that sentence out of 24. Okay?
Which one?
The one that we're talking about.
Based on?
Yes. The second based, the third based on it.
Right,
The next
so
last
there's two
sentence.
sentences that go,
Let's pull that out for the moment. The last sentence.
no information about.
I don't think that's that important.
What actually is,
It is,
because the definition is unrelated.
okay. Other than that,
No comment.
okay.
The only tweak I'd like to make to the last sentence, which is no information about, actually, no information about the relationship, right? Between the individuals residing at the property was provided to the board. Can we say no direct information about the specific relationships? Is that okay?
What are we
Yeah,
saying?
yeah.
I mean, there was speculation, there was conjecture about the nature of a sober home is unlikely that it would be relationships, but that's what I was trying to go with.
Wouldn't that be kind of petty when we should be trying to accommodate the disabled? Could we say you can't have a husband and wife there for treatment at the same time?
No, we're just going to the definition of dwelling.
I know, it was kind of petty to not to accommodate something like that.
Yeah, good point.
Support on it, but,
I mean, query on how the math work in terms of the 5 and how you count it, if it's a mix of relations and unrelated people, so.
we'll never know anyway.
Yeah.
Yeah, I would, if you wanted to say something, I would say more, no direct specific information about the number of people residing in the property. But I would, to Ernie's point, I wouldn't talk about their relationship. You could have,
No, but we
spouses
have to
or.
talk about, we have to talk about the relationship because it's in the definition of dwelling unit.
Well, it says no more than 5 unrelated people, right?
Right, so we have to indicate what information we have, we're breaking it out.
But that's something we will never know. The building commissioner can't go in and find out, hey, are you married?
Whether we will ever know it or not,
Okay.
It's academic.
Okay, so focusing on the last sentence. Are we good as is? I mean, like I said, we can say no direct evidence, no specific information, however you want to call it.
I'd leave it out. I'd leave it out.
It's fine.
It's fine.
Okay. All right.
So we're gonna excise the other sentence,
Well, I'm just pulling it out for the moment.
okay.
Yeah. Oh wait, well, excise as opposed to delete, I think it's fine. All right, so that's 24. Okay, now, on that sentence, the one that we pulled out about the length of time that people are there, to the extent that we want to make that a different, you were saying it's potential, we can make it a different finding.
Yeah.
Okay. Okay, how do you want it phrased?
You just make it 25. And leave it and stand there on the way it's stated.
Okay, well, I would have a tweak to say this, based on the statements made during the public hearing, there is evidence, I'll take the word reasonable out of it, that appears to show the length of time that such individuals reside at the property. There, I would be willing to go maybe less than 30 days.
Yeah. Okay.
Yeah, I definitely agree.
But if that's not something we can force under the zoning bylaw, why put that in?
It is. Yeah, I like it with the may.
So here's the reason why I'm suggesting we keep it in there. One is, first of all, I don't think it detracts from anything. So in terms of a risk of like, well, you shooting yourselves in the foot, I don't think it does. I do think it's worth noting it in light of the amount of attention and time that was paid to it during the public hearing. I also think that to the extent that one could use transients as a way of interpreting single housekeeping unit, which is part of the definition of dwelling unit. I think we should at least make some sort of comment to it and note it. You know, I understand that the housekeeping unit is a barrel of snakes in terms of how to define it, but I think because transients could be a factor in evaluating it, I think it's worth commenting on it. Like I said, I don't think it detracts from anything.
I would just focus on the single housekeeping unit because that is something relevant. But this particular issue is not relevant, and it implies that it is relevant.
What if we moved it? What if we moved that sentence and maybe unpackaged it, put it into 28, which deals with that?
You mean what deals with with the housekeeping unit?
Yes. We can talk about it once we do it.
Yeah, I mean, I think it creates a point that's not legally relevant. The housekeeping part is, but this part is not. I think the housekeeping part is relevant in the sense of distinguishing a family residence from a boarding house. That's the purpose I see in the distinction in 28. But this element of transience doesn't apply to the issue of a residence in our zoning bylaw.
So let me just make an observation. We're trying to adjudicate a case here as opposed to stating facts that we determined during the course of the hearing. So rather than try to decide whether it's legal or not legal, I think we should just try to make a declaration about what we actually observed and how we'd like to just include it here as a finding.
But Andy, when you put a finding, it is a basis for something legal. Yeah, go ahead.
But that's what we found.
Yeah, but we could also say we found a bunch of other things. We could say we found that they had some dogs in the house, but it's not relevant to the issue.
In that example, you're correct. But in this example, it's appropriate or it's applicable to the discussion that we have actually conducted here.
But if it's not applicable to the law, then it's really not applicable.
Ernie, I'm gonna cold call you, ask you to weigh in. Well, I don't care which one or the other. I'm just trying to move this along so I can get a consensus of how people are feeling.
It is, it's been information we've been discussing all along. And we're going to come to a decision about the commissioner's decision. And it's the basis for this decision we make. So it doesn't, we're going to say that one, it has to be occupied as a dwelling unit with a family or 5 unrelated individuals. That's his determination that it could be a boarding house is not, we do not consider that correct. And our bylaw does not permit that. And I don't see why putting the information in there, it's fine. I have no problem with it.
Maria, thoughts?
Yeah, again, I think it may, like, I feel like it is relevant in the sense that even the definition of boarding house was coming up initially, even if we're finding that it can't be there, that use currently.
Okay, so I have a quick question, is leaving that statement in, is there any potential harm to the validity of the decision?
Well, that's what I was saying. I don't necessarily think that there is.
It is a finding, and if there's no harm, I don't see why I don't see there's a problem leaving it in.
From a legal standpoint, if it's a finding, I think it does suggest or imply that that it's an issue of law that we're concerned about.
It was though.
It was
It was
what?
factual.
It's a factual finding.
It's a factual finding and it was a great discussion among the group. Therefore, since it was such a highlight in the discussion, it should be there somewhere. Saying that we acknowledge that this is the case, but later on, it's, our findings basically will, or our decision basically will doesn't mention it, therefore it's not relevant to the final decision.
We're mentioning it, but it's not relevant to the decision.
It's a finding. There's a lot of things in the finding, but we're also mentioning boarding house, but that's not relevant to the final decision.
Well, it was relevant because there was a question as to whether or not it is a boarding house. So that I do think is relevant in terms of a finding. But the issue of transients is not.
Yeah, please, Robin.
So if the reason you're keeping it in is because it goes to boarding house, does it make sense to put something about it in 22? And I don't know if that
Yeah, no, I was thinking the same thing.
concern, but if you put it in 22, is that, if you want to keep something in about it?
Lenny, what about that?
In other words, as it might pertain to a boarding house as opposed to a single family residence. Is that right? Is that the point?
Or just put, or just
Lift it and move it.
or just move it to in between 21 and 22.
Well, what's the point of putting in between 21 and 22 again?
Because
reason?
by 22, we say it's not a boarding house. So if you
Right.
shift it above it, the indication is that it's relevant to that issue.
In other words, if it was a boarding house, the issue of transients would be relevant. Is that the idea?
In part, yes.
Okay, in that respect, if it's relevant to the issue of boarding houses, okay, I could see putting it in that issue, in that section.
Okay, move that sentence, put it between 21 and 22.
As written.
No, sorry. I apologize. I would change it to say, unless anyone has an objection, please speak up. Based on the statements made during the public hearing, there is evidence, with the word reasonable, that appears to show the length of time that individuals at the property reside maybe less than 30 days.
There's evidence that appears to show that
Individuals who reside at the property.
Okay.
Maybe less than 30 days. There might be a grammatical issue there, but sorry.
there's evidence that appears to show that individuals who reside at the property may be
There,
there for less than 30 days.
Or you could add back in the length of time that individuals.
For sure. I may have skipped over that by accident, I'm sorry.
Okay. At the length of time, maybe 30 days. Or less than 30, less than 30 days.
Less- Okay,
That works.
perfect. 25.
Okay, all right.
I assume 25 is okay? Good.
That's-
26. Twenty-six is okay? Yes?
Yep, good.
Good. 27. Assume that's fine. So regurgitation of the bylaw. Okay, 28. So I think the question when it comes to, so let's split this in half. Are we okay with one, two, the first three sentences? This is basically the non-highlighted part.
Not defined,
Do you
yeah.
want to add anything or delete anything? Please speak up.
The only comment I would make is the same, instead of the board has heard, I think we had a different way to state what was presented, but other than that,
You could take out the has probably.
I'm sorry, Robin, was it?
You could probably take out the word has and so.
Oh, yeah, yeah.
Yeah, I think that looks good.
Okay. All right, so if we're good the first half, what, if anything, do we keep for the bottom half, the highlighted section?
I think we can just drop it.
I mean, I like everything from the board down. I think it interprets that to me. I don't know if that has any meaning at this point.
I like Michael's
Yeah, I think-
suggestion.
I think I agree with deleting it.
Andy, I'm sorry, I heard you said, but I didn't understand it. Can you say it again?
Sure. Basically, to simplify it, take the, interprets that to mean
Yep.
All the way down to living room.
Yep.
Take that out and everything else to keep. So that's essentially that first sentence.
Or I guess that's a half sentence, who knows what that is.
So basically, the board did not receive any information from which it could conclude that the occupants of the sober home are not acting as a single housekeeping unit. In fact, contrary to the contrary, butters reported seeing multiple people in the dwelling on the properties congregating together and watching television. I think that's a good statement. I'm not sure the one above it adds anything.
Have I heard from Andy and Ernie, sorry if I'm putting words in your mouth. Am I correct? You guys would be inclined just to delete all of it?
Well, after listening, I think. That,
You can't
I would-
flip flop,
I would-
man, come on, we're
I'm
trying to
not
make progress here.
flip-flopping. I would agree with Andy's suggestion to modify it, take that interprets.
Okay, well, okay, so at a minimum, we can say that interprets through living room is out.
Correct. Not a lot of that.
I don't particularly like the last sentence. I mean,
I agree with it. I agree with
I'd
that.
rather just say, this is what we heard.
Oh,
Almost,
in fact, right,
yeah.
yeah.
Is anybody fighting hard to
Yeah,
keep the last
yeah.
sentence in?
I like the whole paragraph, I mean, the whole highlight, well, the whole section.
You're breaking up.
I'm sorry, Lenny, do you mind repeating?
I'm
this,
sorry.
please?
I said I don't have a problem with the whole section, including the whole highlight.
Well, I mean, the third sentence already talks about them watching TV, and the last sentence seems to contradict that, so that's why I'm sort of inclined just to keep the more basic. People saw them watching TV, and then just cut the last part. See what I mean?
Yeah.
Okay. All right, so we're gonna cut the last sentence. All right, so that leaves the next to last sentence. Personally, I think, not to quote Lenny, I find that
What's-
sentence to be too definitive. I'd rather just say we're unable to determine. Because the reality
Yeah, I
is
agree.
that did not receive any information from which it could conclude. Well, I disagree, theoretically, we did receive information and we could have concluded. Like, I think that goes too far. I'd rather just say that we're,
So delete the last sentence.
well, I'd rather either delete it or say we're unable to conclude. Based on the information provided, we are unable to conclude.
Yeah, I like that.
It's more neutral. We have some information, but we don't think there's enough, or there's too many open questions, whatever it might be.
Instead of turning it negative, how about saying, the board has received information, which indicates that the occupants may be acting as a single housekeeping unit. So I mean, isn't that what we're trying to say, is that we believe that they're in their, because we acknowledge we see some information which could indicate that they're acting as a single housekeeping unit.
Yeah.
The problem is
I mean,
that,
yeah.
the problem is how you interpret the information. You could actually argue that we have information that could indicate that they're not.
Well, we were willing to say that looking at 9 beds indicated an issue where there may be more than 5 unrelated people. I mean, if we're going to use 9 beds as evidence, I don't see why we can't use the information in this paragraph as at least evidence of some communal or congregated living arrangement.
I wouldn't equate the two.
You would
Right.
equate the 9 beds with the people watching TV together?
I would say 9 beds is better evidence that there's more than 5 people living in a house, and saying
That they get along.
the fact that people are watching TV is not necessarily a single housekeeping unit.
Yeah.
I'm not saying.
I think that's weaker evidence of it.
I mean,
I just don't think it's enough.
it may not be enough to prove it, but it's evidence.
That's why I'd rather say we're unable to find. That way we don't have to go one where it's more focusing on the burden of what needed to be proven, and that there's just not enough for us to show. There's not enough to show it.
Well, I don't think there's enough to show that there's more than 5 unrelated
It's-
people with 9 beds.
Well, okay, we don't need to relitigate that fact. Robin, go ahead.
Just for discussion, just language, I mean, you could say, based on the information provided, the board is unable to conclude that the occupants of the sober home are not acting as a single housekeeping unit,
That's where I'm going.
just for your discussion purposes.
Are not able to conclude that they are not acting as a housekeeping unit. Is that right?
Yeah,
No.
unable to conclude that they are not acting as a single housekeeping unit.
Okay. All right.
Right.
I guess I would tweak that to say, based on the information.
Sorry.
Go ahead, Maria, sorry.
Oh, sorry. I just, the radio there came on. Sorry.
No. Didn't even hear it. It's okay.
Okay.
How about this? Based on the information provided, the board is unable to conclude whether or not the individuals residing at the property are acting as a single housekeeping unit or not.
The only thing I'll say is ultimately you have to get to a decision based on,
What'd you say?
like, ultimately you do have to make a decision. So,
As to whether or not they are acting as a single housekeeping unit or not?
whether or not there's a violation.
I understand that, but for these purposes,
Sure.
Like.
I mean, I would go more in the direction of what's already there, because we did that in terms of trying to show that there may be evidence of that there may be more than 5 unrelated people. So if we can put that evidence in, I don't see why we can't put this evidence in to say that there may be some evidence of a single housekeeping unit.
Because I Okay, well, I'm not gonna agree to that, so, like, what do you want me to say? Do you need to go or you just stretching?
Oh, no, I just need to stand up.
No, that's okay, I just wanted to.
No, I just, sorry,
No,
just
no,
standing up for a second.
That's all right, I've got a back issue as well, so I'll take other suggestions.
Personally, I like the way you worded it, so.
Oh, thank you. Maria, thoughts? Sorry.
I like the way you worded it also.
You guys good with it?
Could you hear that?
Yeah, I heard you.
Yeah.
Okay.
All right, did you write that down?
I did.
Okay, all right,
Do you want me to tell you what I think you said?
yes, Robin's gonna read it out loud, and we're gonna vote on it, and then we're gonna move on.
Okay, so I think what you said is based on the information provided, the board is unable to conclude whether or not the sober home is acting as a single housekeeping unit.
Okay, I would change that to simply say, rather than the sober home, I would simply say the individuals residing at the property are a single housekeeping unit. Okay. All right, we're gonna vote on that sentence, and we're gonna move on. All right. Andy Demore.
In favor.
Favor. Ernie, favor. Maria?
Favor.
Lenny?
Opposed.
All right, I'm in favor. We're keeping. Moving on. Section 29, oh, sorry, not section, sorry. Proposed finding number 29. That has problems. Sweet Lord. All right, the building commissioner had some communication with sober home operator. Okay, so the first. All right, well. So on 29, and I'm sorry, I don't know if it's not the way we drafted it. The communications that's referenced in the first sentence, who is that with? Is that the late fall one, or is that the one that was more recent? Or is it meant to be sort of an aggregate?
In both cities.
Sorry, the first sentence.
I'm just trying to think back.
No worries.
If you read
I-
that,
I think that's just leftover
Okay.
at this point, because other things were deleted.
Okay.
I think it should just, the rest of it just cuts right into a determination.
well, the way I looked at that, that looks as if it's alluding to the two emails that the building commissioner issued. We had some communication problem,
Yeah, I'm just gonna throw this out there. I don't know why we need to keep 29.
right?
The whole thing?
Yes. It's not a factual, it's not, we're making a determination, that's the vote. It's a factual.
Didn't he say that they could be in time?
No, I know, but we covered earlier what his decision was and his communications.
I think as long as you ultimately capture it in the vote part,
That's right.
you know,
Yeah, because like if you go back to 8, it says the building commissioner declined to take any enforcement action. The building commissioner restated that the property can be operated within the bylaws definition of either dwelling unit or boarding house. The building commissioner informed the owner of the property that it may only operate as one of those lawful uses. Like that's a retelling of his decision. And then his communications are the letter, which is referenced in 6, and then the phone call he had in number 7.
Has he ever told them that they can't have a boarding house?
Not specifically, he simply,
He said they can.
right, if they follow the bylaw.
Yeah, I think you're saying if you are operating within that definition, you could.
If I'm not understanding, I'm sorry.
Well, let's see what our final decision is that we send to the owner.
Okay,
Okay, and then
So if it is a boarding house, there's certain bylaws that are applicable that are not
they can't meet it.
correct. Yeah, okay.
So for 29, are we cutting it?
but if I'm off base, please,
Oh.
like,
No, in previous decisions of the board, they have made some of these determinations in the findings.
Okay.
And then it just gets restated in the vote. So as long, as Robert said, as long as it's captured, it's okay, but we wanna make sure that it is
captured somewhere.
captured somewhere.
Okay,
So,
I would be inclined to cut 29, as it's not a factual finding, and just,
I can see the redundancy that you're saying, yeah.
Well, there's some ambiguity there as well.
yeah, well, I don't think it's, the way it's written now is somewhat inconsistent with how we've now phrased other paragraphs as well, so I'd rather just say we said it before, and now we don't have to worry about repeating. Okay, so we're gonna cut 29. And then with 30.
Okay.
All right, thoughts on 30? And dwelling unit
Being used in a manner inconsistent. It is inconsistent in that they have more than 5 people there.
So, I'm sorry, I'm trying to read your comment here. So you wanna sort of re-acknowledge the definition by putting it in here? Is that right?
It has been in the past used in a manner which is inconsistent with the definition of dwelling. Unable to conclusively find that the property is being used. We did find it was improperly being used because they had more than 5 people there.
But that's
We
only
haven't proven that.
that's only one factor.
That's conjecture. Proven that.
I'd rather leave that out. If it's the case.
What, 30?
I think someplace we've got to make a decision.
No, I understand.
And it's not here in this decision as far as what needs to be sent to the owner.
Well,
This is filed. How do we get the information to the owner? We send a separate letter?
No, so when you issue this decision, whatever it is, the owner by law gets a copy because they're an interested party anyway. Now, if your decision includes a directive to them, I think that you shouldn't just say, here's the decision we filed. I think
Okay,
you
we need
say,
a directive here also then.
No, well, I don't know where you're going with this, so I think you all need to have a discussion at this point about kind of like what your ultimate conclusion is gonna be, and then we can work on the language. Like, I don't know what you're ultimately going to find.
Because the building commissioner left open the option for a boarding house in his decision, did he not?
So
A dwelling unit and a boarding house.
I know, but I think we said it can't be that.
Okay, but we
Well-
gotta be specific to the
Oh, no,
owner
I understand that.
stating that.
Well, right,
But we do not agree with the building commissioner's interpretation of the bylaw,
well,
allowing a boarding house. Only a dwelling unit could be used there, which is
Well,
limited to
I think
500 people.
I think the way I read the building commissioner's decision is he said, conceptually, you can have a boarding house there if you follow the bylaw.
which was apply for a change of use.
And then he stopped.
In a way, it doesn't make any difference because if it's a boarding house, it's only 2 people anyway, and
You know, I think that's always the part that we've sort of struggled with, which is that like he went up to the line without saying,
yeah,
oh, and by the way, I think you're violating this or not violating this.
right.
It's say, here's the law, or here's the bylaw.
comply with it.
This is how you comply with it. Do so. You know, and I'm not doing anything else right now. There's an implication here, I think, by declining to take action, and that's how the appeal gets here. I think, which is why I think there is this narrow path where we can go, yes, he quoted the bylaws correctly, and he correctly said if you can follow them, then you can do them. And then we can take the next step to say, and oh, by the way, you know, you need to show that you're actually doing it, or we think you're not doing it, or whatever it may be.
Yeah, so just to clarify, I agree that the questions before you are both, did the building commissioner properly articulate the law, how the bylaw works, is one question. And then another question for you is, essentially, was the building commissioner correct to not take any additional zoning enforcement, or are you finding a basis for additional zoning enforcement? And I think you have to kind of have that conversation before you can decide what the words are gonna be in here, because I don't think you have consensus on that right now, but like I said earlier in the meeting, you could theoretically have a decision that says that you are, denying so much of the application as is appealing how the building commissioner laid out the law. Yes, this could be a boarding house, it could be a dwelling. That's one part, but then you can go on and say whether or not you are granting or denying the appeal as to whether or not, in fact, there's a zoning violation. But those are all the questions, you wanna make sure that you answer all the questions that are parts of the appeal. You wanna make sure it's clear from your decision that both the legal and the facts applied to the law parts were addressed. I don't know what those answers are gonna be yet.
All right, let's break this down. So,
So we have a decision on for the appeal.
right, the building commissioner's decision.
Right.
Or technically 2 decisions. They're essentially the same.
Now we need to inform the owner. Well, Frank did it, I guess.
Let's not worry about that part. Let's just worry about part 1, which is, are we agreeing with what, is there sufficient information that's been provided during the hearing to find that the building commissioner's decision should be overturned? Like, that's the base decision. Whether we want to do something afterwards is part 2. We can, so let's just try to answer part 1 first.
Well, I got a more basic question, which is, did he really even make a definitive decision?
Well, if he didn't make a decision, then, Lenny, I completely 100% acknowledge your point. But I think his declination to take action is in and of itself a decision. I mean, the written decision is restating the bylaw. His declination to take action is a decision. Does that make sense? Otherwise, I don't mean to be sort of blunt about this. If he didn't make a decision, then the applicant couldn't have made an appeal, and then we couldn't have rendered it, we couldn't be here.
I do think it's fair to say that he declined to take further enforcement action, or any enforcement.
Right.
And that's been appealed to.
That's the reason why I was a little nuanced in my decision in saying, it's not that he found something or decided something, he declined to take action. I think that's a more specific way of putting what he decided to do, which is, it's fine, that's his discretion.
Declined to take action beyond a point, because he did take action, right, by issuing the statements that he made, right?
Oh, that's true, yes.
He declined to take enforcement action, right?
Okay.
He articulated the law.
Okay.
He told them they need to operate within the law.
Yeah.
And I think David said it well, and that implicit in that is there was no warranted enforcement action.
Right.
So what's before you then is an appeal on the issue of the law, an appeal on, should enforcement, is there a violation? Should some enforcement be ordered? And I don't hear the board has reached a decision on it.
Does by enforcement, does that like include investigation, or that means it has to be, the issuing the
I think the
desist?
menu of options, I think the menu of options is essentially either we say, and people can brainstorm with it, so that's fine. The menu of options are, we find that they are not in use based on, factors 1, 2, and 3, whatever that might be, and we're issuing a cease and desist order, with respect to that violation. That's option 1. Option 2 is, we make some indication that we have questions, we have concerns based on what we've discovered during the course of the public hearing, and we are ordering the owner of the property to provide sufficient evidence, put whatever phrase you want in there, to indicate that they are in compliance. Theoretically, option 3 is neither of those, and we punt it back to the zoning enforcement officer and we ask him to do it as opposed to doing it ourselves. That is theoretically an option. That would be option 3. Option 4 is we don't do anything. We simply say affirm or deny, whatever, and we go home. And we can choose to do that, if we want. I think those are the 4 theoretical options that are out there. If people have other options, I'm open for those. Yes?
I'm always drawn to that kind of punting it back, number 3, I guess. Is that something we truly can?
Sure. I mean, we could simply say, hey, building commissioner, but yes, but it's a request. I mean, it could be declined. There's no teeth behind it. It's not really a decision per se. It's really it's a request. I mean, in all honesty,
Right.
One could argue that it's not even actually in the decision. We could issue a decision and then write a letter saying we're asking you to do this, the same way that we ask other town staff or town boards over whom we have no power, hey, we think we have a good idea, you guys should go do this, and it can be acted on or ignored.
Can I help maybe just to break it down to?
Please.
Okay, so I think the first question is, does the board agree that a sober home could operate within a boarding house if it is meeting the definition of boarding house? So that's one question. And the next question is the same for dwelling unit. Can a sober home operate within a dwelling unit so long as it meets the definition of dwelling unit? So those are the legal questions, right? That's what the building commissioner had, and that's what's before you. So for example, if you say yes to both of those, which is what 29 was trying to just get you through the analysis, right? So if you say, okay, yeah, the board agrees that a sober home may operate within either of those definitions, so you would deny so much of the appeal that is saying they can't do that. You're affirming that the building commissioner said that can happen. That's one part of it. Then the second question is, you know, is the use, does the board find that there's a violation of either of those uses? Is it operating, you know, and you could say, and you've already said, you know, we don't think it's violating boarding house, we just don't think that what it's doing constitutes a boarding house. Okay, so is there a violation that you find of a dwelling unit use? And if you find yes, it takes you in one direction, and if you find no, that's kind of where you start talking about, well, even if we don't find a violation, what can we do right now? Like what else?
Yeah, but Robin, what if we're not sure? You know,
Well,
in
the thing is, you
terms
have
of the
to make
family
it.
residence.
So the applicant has the burden of proof, and you have to make a decision.
Well, can't we make a decision? I think David indicated them in options 2 and 3, where we basically take an investigative procedure to find out.
But I think you need to make a decision either way. You have to act on the appeal that's before you. And so ultimately, if what you're saying is, I don't have the information to say there is a violation, then I think you're saying there is no violation, because that burden hasn't been met in your mind. And I think that under 4814, you could say, we are denying the appeal in its entirety. We think a sober home may be a dwelling unit. We think a sober home may be a boarding house. We don't have the information to find there is actually a violation right now with the limited information that we have. So we're denying the appeal, we're affirming the building commissioner. However, we are also, because we have the authority, just like the building commissioner, to issue orders, we are ordering the applicant to, or I'm sorry, I keep saying applicant, we're ordering the property owner to give the building commissioner information or whatever you want to order. I still think even if you deny the appeal, you have the ability to issue orders. So, you know, for example, a building commissioner could say, someone could come in and say, I like zoning enforcement. The building commissioner can look at it and say, I don't see a basis for it, and now I'm gonna reach out to the owner, I'm gonna tell him, you need to give me X, Y, Z, and if he doesn't get that information, you can make inferences from it. You could say, well, you didn't give me any information, so I take it there's, you know, a violation or what have you, but you need to decide this appeal. And because you have a burden of proof in play, if ultimately you can't find there is a violation, then you're kind of doing what the building commissioner did and you're saying there isn't. But you have to act on the appeal.
Oh, yeah, no, I'm not saying we couldn't act on the appeal. I'm saying we can deny the appeal based on their allegations, but at the same time, feel that there's been some issues raised where we should take some further action, whether it's through our own request for information or asking the building commissioner to look into it.
Yep, and that's why, you know, I was asked to suggest language, so that's what I did, which was essentially that you're denying the appeal because the evidence doesn't move you to find there's a violation, but you're ordering the property owner to get the building commissioner the information he needs to make a decision within a certain period of time. And if that doesn't happen, there'll be further basis for zoning enforcement.
Yeah.
And that's just one route. I'm not saying that's how, I'm not making this decision for you, but I think it is very important that a full decision on the appeal be made.
Oh, yeah, I agree. We can't say, you know, we either have to accept or deny on the appeal. Because it is, you know, an appeal, not an appeal. It has to be a yes or no. Right? I was just, you know, in terms of the what we discussed earlier, though, apparently we have to if we're going to do something in between, say 2 or 3 of David's option, apparently we have to do either 2 or 3. We can't do a combination of both based on what you were saying earlier, if I understand you correctly.
Yes, that's correct.
Okay. You know, through this whole hearing, I'm going every which way. It's been a problem, and I keep changing my mind on what I would like to do. But I just read over the
Which is why I always say at the beginning,
yeah,
nothing gets decided until we vote.
yeah. But looking over Frank's letter to the owner, he's basically saying you have to comply with the bylaw. You can be a dwelling unit or a boarding house. And the boarding house limits it to 2 people. And if you want more than that or a different arrangement, you have to get a special permit from the ZBA. I agree with this decision. And I don't think we need to, I think we should let him be the interface with the owner. We should just ask Frank to please send out enforcement letters saying you need to provide more detail what's going on, because at one time it's a sober home, now the owner said it's gonna be rented to a family. Well, what is it? And right now, Frank doesn't know for sure. I think he needs to challenge or force the owner to respond to him in writing what's happening. But Frank's decision is fine, as far as I'm concerned, looking over everything.
Let's just focus on Frank's decision first. We'll take it in steps. Andy, do you want to weigh on just the decision piece? And mind you, by the way, I want to be very picky about this. While there's a lot of language that's the same between the letter and the decision being the emails to Mr. Birch and to Mr. Schwartz, which are attachments 6 and 8 of the application. Technically, they're different, so I just wanted to mention that. But the language is very similar. So, Andy, your thoughts?
Substantially similar.
Yeah, so, no, I think that the building commissioner has actually made a decision, and it's in writing, and we know what that is. And I think we can act on that, and we can make a choice here as a board. I would disagree with asking the building commissioner to do the enforcement part, because I think we have to include in the decision and direct it to the owner of what we really need to do, because if I got the gist of this, we can ask the building commissioner, but he's not obligated to follow up with that, right? However, if my understanding is correct, if we put it in the decision, then it's incumbent on the owner to actually have to do something about it. In that case, if there's no compliance, then there's a different set of actions that can take place.
I think that's fair. I would also say that, and again, I want to make sure we do part 1 first.
Sure.
On that, we can be specific. Like if we're the ones making the ask, we can make the ask as opposed to relying on someone else doing it in whatever way they want. But okay. Just on the issue of the building commissioner's decision, Maria, thoughts?
Yeah, I like what Ernie said there.
Okay. Lenny?
Yeah, I think, yeah, I agree with what the building commissioner said as far as he went, in terms of how we interpreted the situation. But I think the decision we have to make now is how we want to deal with that situation in terms of, do we want to, make a decision, or do we want to ask the building commissioner to make the decision?
Okay. All right. So let's break this down into pieces. If we're all good with that. Give me one quick second. Sorry. So if I'm getting the straw poll of folks' opinions, under section 5, the first, I guess, so we make 2 choices. We can either reverse course somewhat and work with paragraph 29 and essentially kind of, I think, we just rework that a little bit. Or we can just include that language in section 5 of the vote, which I think is somewhat encapsulated by the first 2 sentences of paragraph 3. I don't really care which. People feel strong on one or the other. I'm also happy to just. I mean, we can also go ahead.
Paragraph 3, I'm sorry, I just lost what you were alluding to there.
Paragraph 3, the first 2 sentences, the board further states that generally a sober home is allowed. I mean, we could change those 2 sentences to say, the board generally agrees with the building commissioner that, and then, you know,
So like,
Sorry, are you
can
talking
I-
about paragraph 29?
Lenny, sorry, one second, sorry, go ahead.
Yeah,
Ron.
all right.
So I think the part of 29, however you word it, that says that you agree that the building commissioner correctly determined that the property may be used as a boarding or rooming house or dwelling unit, and that the building commissioner properly determined the use appeared to be dwelling unit, like needs to be in the vote part if it's not gonna be in 29. Because the way the vote's written was with 29 in there, and then it's really focusing on dwelling unit, it's not even talking about boarding house. So because the appeal involved those different issues, I do think it's important that they get in here somehow. So for example, you could say, instead of further states, because now you're not further stating it because you cut 29, you could just say, you know, the board states that a sober home is allowed within the residential district when conforming to the parameters of a dwelling unit or a boarding house as described in the bylaw in this decision, right? And then you could say the board agrees, I don't know that you need I don't know, the next sentence I almost think gets repetitive at that point, but I think like if you're gonna cut 29, I think you need to have a finding in here on those two legal issues, and then say how to apply.
All right, how do we do this? Okay, here, I'm just gonna propose this idea so going back to paragraph 29, can for a moment. Okay. First, we cut the first sentence. I don't think it's relevant.
Yeah.
It's repetitive. Okay, that's one. Second is, I would change the second sentence to read as follows. The building commissioner correctly determined that the property may be used as a boarding house, boarding or rooming house, or as a dwelling unit, provided that it complied with the bylaw.
Yeah.
Sure.
Okay.
Yeah.
I'd like to reverse boarding and rooming house with dwelling units, so dwelling unit comes first, can be better.
That's fine.
Yeah.
Okay. Tell me when you're good.
The next line, I feel like doesn't match his email.
I know.
I know it's the line that I keep picking out.
No, you wrote it. I understand. Why can't we just simply convert the second sentence, sorry, the third sentence, I apologize, to the building commissioner informed the owner of the property that
The owner of that there would be no more than 5 unrelated individuals as allowed to reside, or that are allowed to reside at the property. You can take out the terms properly determined.
Well, just say that he complies with the regulations for dwelling unit.
that I like.
Can you repeat that?
Andy,
Okay.
yes,
well,
you.
Sorry. So, that appears to be a dwelling unit and inform the owner that they need to comply with the regulations of the bylaw to operate as such.
Is that, so the board's in agreement?
Yeah.
Yeah, that works.
But you had just added, provided it complies with the bylaw. first sentence.
You could do that too. But you want it to be pegged back to the dwelling unit statement, right?
Well, because he kind of repeats himself, you know.
As long as it drops that part about the building commissioner properly determine the use to be a dwelling unit. Unless
To
we're
what?
separately making that determination.
And that's what he has, that's what his decision has rendered. The building commissioner did.
No. I mean, isn't it simply isn't it really actually, the building commissioner correctly determined that the property may be used as a dwelling unit goes first.
Dwelling unit, boarding house.
So, the building commissioner correctly determined that the property may be used as a dwelling unit or as a boarding or rooming house.
Mhm.
And informed the owner of the property that such use required compliance with the bylaw. Period.
There you go.
I don't think we
Yes.
can say anything else.
Yes.
Yeah.
I agree with that.
Okay,
And so that's just the
that is
combination of,
that is the entire section 29. Got it. Okay, so 29 is reinserted with that sentence.
yes.
Excellent. Okay.
So how's 29 reading now?
Sorry, can you reread that?
The building commissioner correctly determined that the property may be used as a dwelling unit or as a boarding or rooming house, provided that it complies with the bylaw.
And you wanted that and inform the owner of that.
And
And
inform the owner.
I think that's what the last part was.
Good. Okay. Do we need 30?
I mean, I think you need factual findings that support your ultimate conclusion. Well, how you get there, you know?
But if the question is, all right, I'll open the board to 30.
So you're trying to decide whether to leave it
Well,
in, take it out, or edit it.
Yes.
All of the above. Actually, sounds like the decision, right?
I mean, you can move it down if you want to. If you're more comfortable with that.
So limited information, say testimony.
Well, I think
I don't think you can use that term,
what testimony?
testimony.
Testimony.
Doesn't it have a connotation to it?
I would say it does. Also, testimony would not also include any like documentation, records, things like that was provided. We can say statements, references.
Residence statements.
Yeah, okay. How about this, if this is okay? Based on the limited information available to the board, which included documentation and
Discussion.
I was gonna say, statements by the applicant and members of the public.
What documentation did we have?
All the documentation that the applicant submitted.
Was that actual documentation? It was more opinion.
He provided police records, he provided
A
emails.
multiple page document.
There was, I believe, there were articles
Yeah.
that were provided, so.
But not specifically relating to this particular sober home.
It doesn't make it, but it's, I'm just saying documents. It's based on the record.
You wanna just say that based on the record available to the board?
That's. Are you good with that?
Yeah.
Sure.
Well, yeah, those are all spelled out anyway.
Sure. Based on the record available to the board. Change the first sentence, the first phrase that way. Any other thoughts or comments on 30?
So can you read out what it is now?
Based on the record available to the board, and not giving weight to conjecture and generalizations about sober homes, the board is unable to conclusively find that the property is being used in a manner inconsistent with the definition of dwelling unit or otherwise in violation of the bylaw.
Do you think it's missing anything with that statement, or?
Do you think it's missing anything with that statement? I'm sorry, I'm not trying to probe. It's
No,
just
I mean,
like,
I'm just wondering, I'm thinking it sounds fine for what you wanna say. I mean, I don't know that you need to add anything.
Okay. Andy, Ernie, thoughts?
No, I'm happy with the way that was just stated. Well, I'm just kind of rattling around in my head is that, I think, is actually the decision.
We move to section 5.
Yeah.
I mean, that's fine. I tend to agree with that. Because it's a conclusory statement. Ernie, what are your thoughts?
I'm fine.
Maria, Lenny?
Yeah, I think it's fine.
Okay, are you guys okay moving it from section 4 to section 5?
Section, I thought this was section 30.
No,
Oh, I
that's-
see. Oh,
Yeah, he means the next.
Yeah,
Oh, I
just
see.
moving it
I see. Put it under the vote. Okay. Yeah, that's fine.
because it's more of a conclusion rather than a finding.
Right. Okay.
I agree.
Um, Are you comfortable building into the first paragraph of section 5, or do you want to suggest an idea?
It's already basically represented. That's it. Almost strike some of that.
So should it start off with based on the record available to the board and not giving weight to blah, 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 kind of, it is used in a manner consistent with that dwelling unit or otherwise violation of bylaw. the board by a roll call vote of 5 members participating members present votes to blank in the blah 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 appeal of the 2 decisions of the building commissioner at issue in this map.
So before we take a, oh, go ahead. I'm sorry, Michael.
Is that what you want that first paragraph to say? Just start with 30 and then go into, because of this, by roll call vote, here's our decision.
Yeah, I think the way to, yeah,
What are we going to do about in terms of commissioner or what else we want to take?
Can't hear you, Lenny.
Sorry,
Oh,
Lenny,
sorry.
you were
Okay.
really muffled there.
Is-
Can you repeat?
Is that better? Is that better?
Yeah.
Yes.
Oh, good. Okay. That's fine, but what about a decision in terms of what, if anything, we want the building commissioner to do?
That's next, one thing at a time.
Oh, okay. So that'll come
That's
after
okay.
the vote. Okay.
Yeah,
Okay. Got it.
from my perspective, that's a second vote.
I see.
What if you move 30 down,
Right,
and then you just, so you have 30, but then you just keep the next paragraph that's there too, because I think you wanna keep,
Yeah.
referencing the entirety of your findings.
right, no, I'm just trying to, like, figure out whether or not we need to essentially combine 30 with the first paragraph of the vote, or if we can actually let them both sit as separate paragraphs.
I don't think it matters.
Okay.
I mean, the words are in there,
Okay.
however you wanna do it.
In that case, let's just take 30, move it down as the first paragraph under the vote, and then the current first paragraph becomes the second paragraph. Okay,
I mean, if anything, I would leave the current first paragraph to 5, your vote.
Yeah.
Right, and then you could move 30 under it somewhere, cause you need like the vote, and then you can give your explanation for the vote.
I mean, I'm fine with that too. Yeah,
So it'll be
Under the signatures, under the yays and nays.
under the yeas and nays section.
Yeah, like under what says Andrew was here, like, did vote, then like the next thing could say, based on the record, and then if you
Okay.
wanna include the additional findings,
Okay,
you can go through that and ordering anything.
that makes sense.
okay. All right. Any other questions, comments, or edits on section 4 to the findings? I'll take silence as not. Okay. Anything from you?
Yeah.
Okay, thank you. All right, and then so 30 gets moved down to section 5 as we talked about. All right.
When notwithstanding repeats the paragraph we just moved down. Okay.
So what I'd like to suggest then is that in section 5, in the paragraph that begins, the bird further states, you see that?
Yeah.
I believe the first 2 sentences can be deleted.
Correct.
Okay.
Sorry, which one was that?
Section 5, Roman numeral 5, under vote.
Yep.
Okay. The paragraph, the third full paragraph that begins, the bird further states that generally,
Okay, yep.
the first 2 sentences there should be deleted.
Yes, because we already stated it.
Yep, exactly.
Excellent.
Well,
Because it just repeated the one we just moved down, basically.
well, it's basically saying, notwithstanding that fact.
So then you move 30 right there, and then you say notwithstanding.
Right,
So that, I think that makes,
that works.
at least it makes sense like linearly in the
Okay.
document.
Um, Okay, so the question, the second part now is, can I just ask from a procedural standpoint, can we take a vote on the building commissioner's decision and then discuss if we want to do anything else, or do we need to do it before we take that vote? Because what I'd like to do is actually should we have two different votes? One for the decision and one for section 14?
Well, it's up to you. So for example, you could take a vote to either, grant or deny the application. And then you could take another vote that says, and we vote to adopt this decision as, as amended by the board tonight as our decision,
That's right.
and that would include the remedies in it.
Right, okay.
Or you can take multiple votes, but
Yeah, no, that works, okay. Okay, so why don't we do this first? What I'd like to do is, let's do this, just to lock this in, if that's okay. I'll entertain a motion to, on the question of the applicant's appeal.
First part there.
I think you wanna say either to approve or deny, like.
Sorry, to
I
approve.
mean, people should.
I'll entertain a motion to approve or deny the applicant's appeal of the zoning enforcement officer's decision.
Two decisions to be made.
Decisions.
Yeah.
As defined in the, yeah. Specifically attachment 6 and attachment 8 of the application.
Make a motion that the board review the decision and decide whether to accept or deny the applicant.
Well, now you have to move to either do one or the other.
Oh, sorry. Then we move to deny the application as written.
We have a motion.
Second.
We have a motion, we have a second. Take it by roll call vote. Any further discussion on the question of whether to approve or deny the appeal of the zoning enforcement officer's decisions, as noted in attachment 6 and 8 of the application? Hearing no further comment, we'll take this by roll call vote. Andy Demore.
Yay.
Ernie Dodd. Yay. Maria McFarland.
Yes.
Lenny Golder.
Yay.
And
I didn't hear it.
Lenny Golder.
I
Voted yay.
couldn't,
Uh,
did he say yay?
Yes. he
I said
yes.
yay, yes.
I definitely heard.
Okay.
And David Hartnagel votes yay. Okay. With that, we are to now further discuss the decision, which also includes what I would suggest is the last portion of section 5, which is whether or not we want to take any action pursuant to our authority under chapter 48, section 14. So I think, I'll just open it up. So there's a proposed here as to what we could do. People feel strongly one or the other. I know Andy and Ernie have both sort of voiced opinions on that.
Yeah, I'm still there. I just don't know what sufficient evidence looks like yet.
That's a great question. Ernie and Maria, I think Maria, what are your thoughts about anything under section 14 that we may want to do, whether it's as written in the decision or not?
Yeah, I guess I'm still questioning that in terms of exactly what the options are.
Well, I think the options are, we do nothing. We ask the building commissioner to do it for us. We we ourselves order the owner of the property to provide evidence, information, documentation, or theoretically, we could ask for a cease and desist, but I think we've gone so far as that I don't think that's option really on the table anymore, because we've indicated that there's not sufficient information to find a zoning enforcement violation. So I think your options are either we do it. We ask the zoning enforcement officer to do it as a request, because we can't direct him to do it, or we do nothing.
Wasn't there a fourth option?
Break it up.
Well, these are really options 2, 3, and 4. 1 is not really on the table anymore. Sorry, you're a little muffled, Lenny.
When Lenny
Oh,
leans
sorry.
here,
Yeah, don't lean back.
when he sits up, I can just see it in the camera,
Yeah,
when he
right.
leans back, we don't hear.
Yeah,
him.
don't lean back, Lenny, I'm sorry.
Okay, I thought it was my
Just-
earphones. Thank you.
No, move the mic.
Yeah, when you sit up, we hear you much better.
Okay, it's good for my posture. But originally there were 4 options. What was that other one? I don't know.
Yeah, the other option was that we do a cease and desist if we affirmatively find that there's been a violation.
Oh, I see. Okay. All right. All right. So, in terms of my opinion,
Yes.
I don't agree with either options 1 or 4, as you know, that were presented before. I think it's
Right.
to me, it comes down to either 2 or 3. Right now, I'm not sure I can go either way on either 2 or 3.
Well, we're at the point now where we're gonna have to pick. I'm sorry to be blunt, but like,
We can't have it
What
delayed
would
to
the
the
heat-
next. We can't have it delayed to the next meeting.
No, we
No,
got a deadline.
because we literally have 3 days to decide.
Oh, that's right. We got April 9th. You're right. Yeah.
Bumping up on your 100 days
Yeah.
imminently.
So if you
Wait a
want,
minute.
if you want to take a moment to breathe, I'll pick on Maria. Sorry, Maria.
No, that's fine. Yeah, I lean towards the 2 and 3. Kind of still fleshing out.
All right, well, I think down here, if I'm reading the room correctly, I think Ernie is inclined to have the zoning enforcement officer do it. Andy Demore is inclined to have us do it. If I had to serve as tiebreaker, I probably would just have us do it. So
Okay.
that's as much time as I've got.
It's the zoning
So-
officer's job. He's doing his job. He knows how to do it.
But it's not about his job. It's about compliance.
He's,
But if we have an order in the decision, then the owner literally has to provide a response. The building inspector can't, I don't believe, can elicit that same response.
Well, he's also tried.
I know, that's my point.
Okay. He's done it already. So if we're requesting again, it's like requesting him repeat the thing he did already.
I mean, I guess that's my philosophy, is that like, something about, he sent them a letter, he called them, he asked them.
We've been at this
We're-
since
you know,
September.
and it's not his fault, I'm
No,
being
not-
very
no,
clear
I'm not
about that. It's-
questioning that at all.
I'm not blaming him,
No.
like, if anything, he's
There's
tread that trail, you know.
The owner doesn't have any skin in the game here, right? And until you can somehow elevate the discussion to a point where he has to do something, and maybe he chooses not to, that's also a choice, right?
Yeah.
But at least we take an effort to allow that to occur. That's my position.
Lenny, Maria?
Yeah, so
Go ahead, Ruth.
Maria, go ahead, Maria.
So I'm comfortable with us then asking for it.
When you say asking, you're talking about 2 or 3.
I believe 3. So 2 is the request and 3 is kind of taking it on ourselves, correct?
No, I think it's
Well,
the
actually,
opposite.
it was the reverse.
Oh, reverse. Okay, so 2 is taking it on ourselves and 3
Right.
is a request to the building commissioner.
Yes.
Okay.
Using that.
So I think
Okay.
you're basically deciding between, do you wanna order the property owner to do something and provide information to the building commissioner, or do you wanna just ask the building commissioner to dig further into this? I think those are
Yes.
what you appear to be grappling.
Can we not
Yeah.
do both?
No. Well, I mean,
Why not?
theoretically, we could do both. I mean, there's nothing stopping us from
There's
doing so.
no reason there's simultaneous activity to occur as part of our decision. I mean, I know we're gonna conclude the choice here tonight, well, or whenever we finally put the stamp on it. But once we do that, and we can ask the building commissioner to pursue his channel, as well as obligate the owner to do something.
Sure, I mean, you
Well,
could say
that was
you're-
my question earlier, though, and what Robin said was we had to pick one or the other.
No. Because No, because that's slightly different, because what you were suggesting is we do one and then we do the other consecutively. And I
Yeah.
think what Andy Demore was saying is, why can't we do it concurrently?
Oh, I see.
You could include in here that you're ordering the property owner to provide the building commissioner with information, and you're also asking the building commissioner to follow up with the property.
That's right. Right, which is basically doing both at the same time. I think the issue with yours beforehand, and I'm not trying to be picky here, is the fact that you were saying, well, can we try one first, and then if it
Right.
failed, do the second one, and we just can't do it in that sort of successive manner?
Yeah, I
It's
don't
either-
understand.
it's all now or nothing.
I don't understand why we can't do it successively. Frankly.
Because we just don't, we don't have the power to do so.
Once you make a decision
Well,
and
you
you
don't-
render it, it's done, it's
So,
over.
yeah, once you file the decision, you don't have jurisdiction over the matter. The most you would be able to do is, as a board, discuss it at a public meeting and ask the building commissioner to do something.
But that's moot, it'd be pretty much silent on it.
So, I mean, that's the most you could do. You lose jurisdiction over any kind of, formal decision making once you write the decision and file the decision.
Let's see. Ernie, I'd like more of your thoughts on why, you think we should leave it to the building commissioner.
That's his job. He doesn't, he went out, he told the owner, here are your options. Here's what our bylaw says you can do with a dwelling unit or a boarding house. Comply with this. He hasn't heard back, but like he talked with the owner. The owner said, I'm gonna convert it to a family rental or lease. He hasn't heard anything back on that either, but he's quite capable. He knows what he has to do. He knows if something else happens at the home, if he doesn't clear out like he said he was going to with the sober home, then he'll send out a cease and desist. He does this all the time. That's his job. And if we send out the letter to the owner to do it, he can ignore us just like he ignores the building inspector. We don't have any more authority than the building inspector.
Well, although if you put it in your decision and he doesn't follow it, then that in and of itself is a violation of your decision that the building inspector could take enforcement.
Correct.
Okay.
So it's your call, but that's the difference.
I think that's the Archimedes
That's
point, right?
I think that's what's really interesting about this is that if he responds and the building commissioner says, oh, that's enough,
Yes.
and we don't agree, I mean, that's kind of the end of it.
Yes.
If he blows the zoning commission, I'm combining those. If he blows the building commissioner off, the reality is there's no penalty because we've seen that today. The lack of a response to us in and of itself is the violation.
Correct.
It's not the fact that they're not in use. It's the fact that you're violating the order to respond, and silence is the violation.
Okay.
I think that's the reason. That for me was sort of the tipping point. You know what I mean?
Okay.
So
I'll go along with it.
Yeah, it's not about him doing his job,
Yeah.
we're not questioning that at all.
oh yeah,
Not at all. It's a matter of getting a response or having a definitive action that occurs.
Lenny.
Well, Ernie, so what's your feeling, 2 or 3?
Whatever the number, send it to the owner.
To the owner. So the idea, well, see, one of my concerns was that issue about enforcement, that if we just sent out a letter and we got ignored, then basically we don't have anything to back it up. I think any administrative or judicial body always has to be concerned about an enforcement mechanism. But if we can do something and it has to be enforced by the building commissioner, well, then that helps with the enforcement issue. So given that, I think I'd go along with 2.
Okay, so if that's the case, let's take a look at the language that's drafted here, which essentially is, I'll read it because it's redlined. The board, pursuant to Massachusetts General Laws, Chapter 48, Section 14, the board orders the owner of the property Now, this says within 30 days of the filing of this decision with the town clerk. I'm fine with that. And just to be clear, the appeal would run from 20 days from the filing of it. So essentially, they've got 20 days to appeal the decision. If they don't, then they've got 10 days thereafter.
Yeah, and if they appealed it, we likely wouldn't be pushing enforcement at that point, because it'd be appealed.
Well, no, it's appeal.
Yeah.
You gotta get the town to pay for the lawyer to go
Yeah,
take it to
yeah.
court.
Well, and ultimately, any in court enforcement, the selectmen's got
Right.
to weigh in.
So within 30 days of the filing of this decision with the town clerk, to provide the building commissioner with sufficient written evidence for the building commissioner to confirm that the use of the property, I might actually change conforms to a dwelling unit use to simply say that the use of the property conforms to the bylaws.
Yeah.
To the bylaw.
Yeah, yeah.
Now, the only other thing I'm just gonna ask, because I wrote it, is I said sufficient written evidence. That's the best I could come up with. If someone wants to wordsmith it, I'll,
Well, how about just saying, in the opinion of the building inspector, sufficient evidence? So that gives him an option of trying to decide what he would think is sufficient evidence for the bylaws. I'm assuming he has more experience with this and may have, you know, sort of idea of what he'd need for proof.
I would just say sufficient evidence to us as well. I mean, if they were to, for example, show up in a meeting, for example, and present some kind of evidence to.
but it's, the matter's not before us anymore. Once
We're
we issue
done.
the decision, it bounces down to him.
Right.
But I think you could just say, you could say sufficient evidence for the building commissioner, and then it just leaves it to the building commissioner to decide what's sufficient.
Yeah, I mean, to your point, I agree with you. I think it's the reason why I think it's been phrased this way, sufficient written evidence for the building commissioner to confirm.
Correct.
Yeah.
That's where I was kind of going with
Yeah,
it,
right,
without
okay,
saying
yeah,
that
okay.
way too. Because I agree, ultimately.
So either way, whatever that list looks like, if they still don't respond, that's what will provoke.
That's right, that's right.
Yeah,
You know,
that's
the
fine.
alternative is that they're gonna send something to him and
Yeah,
it'll be up
and
to
then we could say, yeah, okay, that's
he,
nice.
he can decide, is an email okay? Does he need an affidavit? Does he need pictures? I don't know what.
Yeah.
But this kind of goes to Ernie's point, which is like, it's his job. He's been
Correct.
doing this for a long time. He knows, in his opinion, what complies with the bylaw and what doesn't.
Yeah.
And, you know, theoretically, if he's got a question, I guess he could bounce it.
So ideally, we're incenting the owner here to do something.
Exactly.
So do you wanna take out written though, and just have them say, provide the building commissioner with sufficient evidence?
No, I think it needs to be written.
I think it needs to be written because of what happened before.
Sure.
Because of the verbal
Yeah.
statement before, I
Sure.
think it needs to be written.
Yeah.
I was just confirming it.
Yeah, no, of course. Yeah, yeah.
Trying to take notes as much as I can.
Thank you. So,
And then the part that said notwithstanding, was that cut or is that still part of it?
no, I think that stays because it links
So the-
30 that moved down. And then it's like, notwithstanding the fact that we're unable to conclusively find that the property is being used in a manner inconsistent with the definition of dwelling unit or otherwise in violation and acting within our authority, then it's the like, we can't conclusively figure this out. But because we've got this authority, we're gonna ask you to prove that you're actually in conformance.
Got it.
Are there any other edits?
So the only other thing I'll suggest is, because you're doing it in 2 votes.
Yes,
That the ultimate form of the decision will include your last vote as well,
yes,
which is that, you know, the board voted to approve and adopt the decision in the form of revised, you know, on this date.
Yeah.
Then it'll actually, it has to get into this decision with your vote on that.
Right.
Like that it reflects it.
Yeah.
Yeah. If that makes sense.
thank you. All right, any other edits, comments, things to discuss with respect to the draft decision at all?
You just have to take the vote.
All right, well, in that case, I will entertain a motion.
And the motion is
Would you
to,
like me to suggest one?
yeah.
I would love to suggest one.
Alright, so I think you can have a motion that the board approve and adopt this decision denying this application in the form reviewed, revised on April 6, 2025.
2026.
Sorry, 2026. Look at that. I can't
That was so
remember.
close.
I can't even remember writing it this morning. So the motion is to approve and adopt the written decision in the form that was reviewed, and revised by the board on April 6, 2026, to deny the application.
I'll make a motion that we approve and adopt the written decision. What's the second one?
In the form.
In
that
the
you-
form
That you reviewed and
that we
revised.
reviewed and revised on
April
April 6th. 26, not 25.
Second.
Well, no, I'm sorry, I don't quite understand this motion. Are we just merging this second vote with the first one? Is that what this motion is about?
No, we are voting, sorry, so there's a motion, okay, so speak for procedurally. There's a motion and there's a second on the motion. Any discussion? In light of the lady's question, I will answer your question, which is that this is a motion to adopt
Approve and
the
adopt.
decision that was previously drafted and has since been discussed, revised, and modified as of tonight, April 6, 2026, which denies the application and further includes an additional order pursuant to section 14, along with the findings and whatnot.
So in other words, this is the same document, but with amended revisions.
Yeah.
Correct, based on the
Yes.
discussion and the revisions that have been discussed this evening.
Okay. All right.
Excellent. Any other discussion with respect to the motion? Hearing none, I'm going to take a roll call vote. Andy Demore,
Yay.
Ernie Dodd,
Yay.
Maria McFarland,
Yay.
Lenny Golder,
Yay.
and David Hartnagel is the chair, votes yay. And with that, the motion passes. All right.
Is it all ready for him to sign?
All right, so Michael will incorporate the revisions as we have discussed and agreed upon tonight. He will then send them to Andy to sign, and then they will be filed with the town clerk.
By what day? What's the deadline?
By Thursday.
It has to be filed with the clerk, yeah.
Yes, by Thursday.
By Thursday.
So I'll send it over probably tomorrow afternoon,
Yeah, okay.
and then if you wanna come in afternoon, if you wanna come in Wednesday, you can also do
You gonna have lunch for me?
that.
I mean, yeah, at least a cup of coffee.
So,
All right.
so when we voted for this last motion, were we incorporating what we'd already decided in terms of our taking action along with the building commissioner? Is that incorporated into the second vote?
Yes.
All right. Okay.
Okay. Amazingly, we're not done.
Right.
I'm now moving on to our next matter. Not need to stay here.
All right.
Thank you very much.
Thank
Yeah,
you.
this was great. Thanks for your help.
Thank you.
You should come to more of our meetings.
Well, as needed.
Um,
That's very
Thank you very
subjective.
Moving on to our next item, which is a request for an insubstantial change to a comprehensive permit with respect to the residences at Stow Acre, 0 Randall Road. Mark is here. Hello, Mark.
Hi, how are you guys?
Well,
Oh,
great.
it's lovely. How are you?
I know you've had a long night, so I'll try to be brief, and if you guys want to kick it off, I'm certainly open to that. I know you've had a long night, so.
Okay, well, I think the easiest way to do it is just to turn the floor over to you to please discuss your request.
Sure.
And provide us any additional context beyond what has been, well, let me just say this. You provided us, obviously, the request in writing, but if you can just refresh our memories a little bit, provide context, and then we can go from there.
Terrific. As you guys may recall, as part of the comprehensive permit, there are 3 phases to Stow Acres. There is 124 single-family homes. There are 25 units within a single building for 62 plus rentals. And at the rear of the site, we had a neighborhood of rental cottages. We had 40 units that were designated. One thing, I think we actually had some conversations about it in the meetings, had to do with, the scope and the scale of it. The project that I had originally proposed was all 2 bedrooms and 3 bedroom units. I have since built a project and have been dealing with several others, and have had consistent requests for 1 bedroom units, to kind of have a broader range of rental rates to help a broader range of people. So what I have submitted to the board is a proposal that would increase that cottage community from 40 to 52 units, primarily by incorporating a series of what I called paired units as compared to duplexes. So they kind of have 2 units that are attached at the rear. So kind of there's a front facing unit and a rear facing unit. And they're the 1 bedrooms that I've incorporated. I've got a 1 level plan that's about 750 square feet. I've got a kind of a 1 bedroom, 2 level plan that's about 900 square feet. That fits really well within the overall layout that we had for the cottages as part of the package. And I don't know if Michael can share it, kind of a before and after. We made those paired units, the duplex units, are in the same locations as the other ones. Really, at first blush, you may not even notice that it's different. There is one section of the property that, as we got into kind of some nitty gritty on the planning, there was some more grading, so we actually moved some units out of an area, and ended up adding a couple more duplexes. We meet regularly with with the local committee, and when I had first proposed it, we were at 48 units. I actually increased it to 52 units because we shifted some units out of some other areas and increased that density a little bit because we freed up some other space. So originally we had 40 structures. Now we are at 40 structures. This is the revised plan that Michael is showing here. If you want to go to the next page, Michael, it has the original one, and I think people will see that it looks pretty consistent. The roadway doesn't change at all. The parking.
So Mark, so on the map, put us on, what corner of the map are we looking at here?
Way in the back.
The one in the back left?
Yeah, the very back of the
Well,
property, correct.
Yeah, okay.
Communal property.
Okay,
The
that's
single
what I
family
thought.
is in front of it, right.
Yeah. Okay, thank you.
Right. So for the most part, if you look at the current plan that Michael is showing, the parking area is kind of behind the units that are between the single family homes and these cottages. You see we've got like 2 parking spaces and open space, 2 parkings and open space. That's really the biggest difference from the plan, is that we beefed up that parking a little bit. Otherwise, we're in the same essential layout. From what you see a couple of units that are kind of the upper parking area that you see to the left of it. We took a couple of units out of there and created some more parking because the grading issues were a little more severe, that we felt it was better to work around it. And overall, as part of this change, we've kind of modified the unit mix. We've incorporated the 1 bedrooms. We have more, a little less 2 bedrooms, but we actually reduced the number of 3 bedrooms. What I found in other sites is that the 3 bedrooms, as the rents get up over, they get up to almost $4,000, sometimes over. There's less interest in them. So we've had, more interest in the smaller units. And that's really fundamentally what we're trying to do with the plan, is to better match it to what I'm seeing as the market need, with a mix of 1 bedrooms, 2 bedrooms, and 3 bedrooms, but maintaining the overall the same layout from what we had before. I did include floor plans and imaging. Michael, if you want to flip through a couple of more pages.
So before we go there, so Mark, can I just stop you for a second?
Yep.
So you changed the layout and you got the split, I got that. One of my questions is, what about egress and fire department? Have you gone through this with them and if they have access to that second unit that's in the back? Because how does that work?
They have the same access that they would have had before. Like I said, the main roadway hasn't changed. The access to the units in the back is the same as it was. We've just literally increased some parking behind the units. But with 2 units, you're not dealing with sprinklers. It's the same fundamental road and driveway layout that you saw. There's really,
Okay.
I don't think any negative impacts from access perspective, fire, police, anything. It
All right.
would, I think, be the same.
Thank you.
Okay. So the design here, the kind of the green unit that Michael is showing, that is a paired unit. That's a 1 level, 1 bedroom. So what you're looking at is what would be facing the street. So we still have, a kind of a smaller front porch, but an interesting streetscape. That is, if you want to shift to the next one, has the floor plan. These are 2 units that are essentially about 750 square feet. Really comfortable sized bedroom, kitchen, living, dining area, nice open. With these units, we're kind of incorporating some patios on the side of it. So they'll have kind of that public front porch as well as a little more private space that you see on the patios that they can use. And you can see the porch in the front, the porch in the back. So the way that the buildings where we located them is in locations that essentially had parking on both sides or access to the street, so that aesthetically, I think it'll work well with with the site plan. Want to shift to the next one, Michael, is a copy of the 2 level unit. Well, those are the elevations. This is these are 2 1 bedrooms that are on 2 levels. Again, really consistent architecturally with what we had before. Nice broad front porch, really 1.5 stories with dormers on the side. These units are about 900 square feet apiece. And again, these buildings, as the duplexes, fit in the same locations as the single units that we had before. So we're pretty much maintaining the same offsets from one unit to another. We're really just treating them with a front and a back entrance. The floor plan is on the next page, if Michael can show that. So again, you can see it, again, nice, comfortable, open kitchen, living dining area. We have a half bath. This has 1.5 baths where the other one just had the one full. But comfortable kitchen. And then the second level has a nice sized bedroom. Laundry is upstairs. Utilities are upstairs, given the amount of space that we had available.
So when am I going to be able to move in?
I've acquired the property. We're still dealing with some MEPR issues, but we're optimistic. In a few months, we're hoping to start. That last page that Michael was showing, really dealing with the question of substantial versus non-substantial. They do talk specifically in the guidelines from DHCD that if it's something under a 10% modification, that it can be considered non-substantial. So the board obviously has jurisdiction. You can decide whatever you want, but I certainly think that this is consistent with the guidelines for the modification that we're looking for. It will add affordable units overall. It will broaden the overall range of rental rates for the cottages, and other than the parking impacts, I think it's a pretty modest change to the site plan, and would love the board's support.
So Mark, what's the percentage increase in the number of units?
We went from 40 to 52. So the overall project is going from 189 to 201, so it's a 6.3% increase in units.
And
So
in
what-
terms of landscape, I mean, does that, the footprint, of landscape, does that, what
No,
changes there in that?
literally, if you look at the original plan to the modification, we actually took out a couple of buildings. So we'll have more area for landscape. Overall, I think that the coverage might be modestly larger, but not substantial. Because with the duplex action of it, the footprints are pretty consistent with what we had before.
So in other words, you're duplexing some of these houses, so you're increasing the units, but not increasing the well, you are increasing a little bit of the landscape, but not like as if you were doing separate units
Correct.
detached.
We
Yeah.
actually, the number of structures is decreasing from 40 to 38. So
Oh, I see.
yeah. So we've actually, I think the overall amount of footprint area is about the same, but the number of structures has dropped, and the layout again is substantially consistent with what was previously approved.
And how many more affordable units are there with this?
We'd go from instead of being 10 affordable in the cottages, we'd go to 13. And again, all of those 12 units would be added to the town's SHI. So you get the benefit of all of them because it's a rental community. And it would incorporate 1-bedroom rents, which we didn't have before. So even the affordable units, I think those rents, where before they would have started around 2,600, now they'll start at around 2,400. So it'll kind of broaden that income level for people that we can help as well.
Any questions from staff?
Just a quick clarification question.
Did we lose Mark?
There's just a different view on the screen.
Oh.
He's still here. When I added up the number of units, it was 28.
28 1-bedrooms, correct.
28 rooms, 14 2-bedrooms,
Right.
and 8
3-bedroom.
3-bedrooms.
Correct.
So that was. And that totaled to 50. I was just wondering where the other two are.
28, 14, and 8. Oh, I'd have to look at it. I made a mistake in my math, apparently. So I'd have to check. It might be 30 on the 1-bedrooms. If there's 15 structures, I can confirm.
And then I counted that there was 38 structures on the site. So
38, yep. Yeah, 38 sounds right.
So it would most likely be either 2 more 2-bedrooms or 2 more 3-bedrooms to get to.
I think it's probably 2 more 1-bedrooms, to be honest with you. Let me see. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 13, 14. I think it would be 2 more 2-bedrooms. You're right.
2 more, so it'll be 16 2-bedrooms. Okay.
Yeah. 16
Got it.
2-bedrooms, 28, there's 14 structures, and all of the duplex structures are proposed as 1-bedrooms. So
Okay.
thank you
Great.
for clarifying that.
Do we need to account for that change someplace?
We do not. I just wanted to confirm.
And also too, from a septic perspective, we actually cut down on the overall amount of flow on the property. The original plan had like 23 bedrooms and 22 bedrooms. So we're cutting down, roughly 20% on the amount of flow, which will, be beneficial for everybody. So we're going from like 11,000, I think, to about 8,800 gallons per day from the cottage section. So.
And the water consumption is down as well.
The same, both of them. Yeah.
Any other questions or comments or concerns?
I make a motion that we approve the non-substantial change to Stow Acres comprehensive permit as described in the April 2nd memorandum from MCO Associates.
Second.
We have a motion, someone seconded.
Andy,
Yeah,
All right, we'll go with Andy. We have a motion.
Andy.
okay, I can vote this time.
There you go. Yeah, we have a motion, we have a second. Any discussion? Hearing none, we'll take this as a roll call. Andy Dwar,
Approve.
Andrew Crosby,
Yes.
Bernie Dodd,
Yes.
Maria McFarland,
Yes.
and David Hartnagel's chair votes yes. So we are accepting the request for an insubstantial modification to a comprehensive permit. There was a draft decision that was circulated. I think everyone got it.
No, it's-
Yes. Good.
Was at the back of your meeting pack that I left on the table.
oh, really?
I can pull it.
Oh.
It's just a couple pages. We can just go through that.
Should I put it up on the screen?
Sure, why not? Maria, do you have it?
Yep.
Okay, great.
Mm.
So I'll open the floor for any discussion, about the draft decision. I'm not gonna tick through this, it's only substantively 2 pages.
Discussion about what we voted on with the draft.
Decision.
The draft decision.
Yeah, the decision. Well,
Yeah.
My feeling is, that, of course, I like to see evidence and I like to see proof, and that was one of my concerns as we were going through the draft. But in terms of
Lenny,
yeah,
I'm sorry, we're talking about the draft decision of Mark's
Stow Acres.
of Stow Acres.
oh, I'm sorry. Yeah, it's been a long night. I'm sorry.
It has been a long night. Yeah.
Yeah.
I thought you wanted to review the whole decision. Okay, fine. No worries. Okay.
Where are you? Waiting in a TSA line someplace?
Yeah, right. I hope I get a ride home.
All right, any edits or comments or questions on the draft decision and insubstantial modification to the comprehensive permit?
So Michael, you've annotated that the head count here is the new head count on the decision
Yes.
that we just reviewed with Mark? Yeah.
Yes,
okay.
that's correct. So we can get rid of that comment.
Are we gonna do this with individual signatures?
That is how the previous comprehensive permit
Oh, okay,
modifications have been.
okay.
So that is up to the board.
The only thing I had is on the second page. I mean, theoretically, word following, I think should not be capitalized.
On the second page where
In conclusion, the board says pursuant to the following votes.
Yeah.
Sorry.
Okay.
Other than that type, I don't have anything else. Well, okay, now I do. 52, I think it's hyphenated, right? Is the word 52 hyphenated?
I cannot
Thanks. Okay. Any other edits, questions, comments, concerns, things to discuss with respect to the draft decision? I'll entertain the motion.
I move that we approve the grant. We're approving the decision.
Oh,
So finally,
Yes.
we're approving the decision for Stow Acres Residence LLC. Located at 0 Randall Road, so Acres, North Course.
second.
We have a motion, we have a second. Any discussion? Hearing none. We'll take a roll call vote. Andy Dwar,
Approve,
Andrew
yes.
Crosby,
Yes. Yes.
Bernie Dodd,
Yes.
Maria McFarland,
Yes.
and David Hartnagel's chair votes yes. So with that, the draft decision with those 2 small modifications is approved. We'll reflect on the executive.
We only need a majority signatures.
Good enough.
So,
All right.
Well, thank you very much, everybody. I appreciate it.
Thank you, Mark.
All right. I know you've had a long night. Go forth and prosper.
All right, thanks, Mark. Take
All
care.
right. Thanks so much. Take care. Have a good night.
Yeah.
Okay. Bye-bye.
Build my house.
I shall. We'll be ready.
Right. You get one color that you want.
Okay, and with that, we are left with one last administrative item, which was a renewed discussion of the correspondence between David Hartnagel and the town administrator, which was submitted for the March 2nd, 2026 meeting. Andy Crosby had asked for it to be brought back as a point of discussion, just with respect to the zoning board sort of operations. So, are we all set? Excellent. There you go. So I think Andy, as you fire back up, kick things off.
Well, I guess, do we really want to talk about it this hour of the night?
You put it on the agenda, man.
No, I know.
I'm just, I'm giving you a hard time. I'm giving you a hard time.
we can table it for,
If you're okay tabling, I got no problem.
I'm okay with tabling.
I don't think we'll have a intelligent conversation at this hour.
That's fine by me. I didn't want to just give it short shrift by saying it's late, let's move on. So
And I appreciate that.
I think that's fine. That being said, our next scheduled meeting is on May 4th. Michael, as he just noted, as of right now, we have nothing on the agenda.
Correct.
Okay.
The caveat, I just remember I talked to 3 people today about applications,
Okay.
so.
Who knows?
Oh,
who
they better
knows
hurry
if
up.
anyone will be quick, But, there's potential for something to be on the agenda.
Okay. If there is no objection, we will table the last item under discussions and move it to the May 4th meeting. And then we'll wait to see if there was anything else as of that date. With that, is there any other matters to discuss of a zoning nature? If not, I will entertain a motion.
Make a motion, we adjourn the meeting at 10:44.
Second.
Motion,
Second.
second. Thank you, Maria. Any discussion? Hearing none. Do you have to roll call this? Oh, sweet Jesus, Michael. Andrew, okay, we'll go to a vote. Andrew Crosby,
Yes.
Andy Moore,
Yes.
Ernie Dodd,
Yes.
Maria McFarland.
Yes.
Oh, I thought you'd gone already.
Hold on, let me think about this. David Hartnagel's chair votes yes, and with that, the meeting is adjourned. Thank you very much, everyone.